Oi, Marco, bom dia. Tá me ouvindo?
Test. Hello, hello everybody.
Hi, Nino. How are you?
I'm fine, thank you. Hi, Giuliano. Good to see you. Virtually,
Yeah.
This is the time, we have to manage somehow, right?
Yeah.
The good thing
Hi,
here,
Nino.
the good thing here,
Hello.
at the time, weather is very good. So I'm giving the talk from my garden.
Yeah, I know that place. I used it when I was there. It's very nice.
Yeah, it is. Well, let's hope that can last even longer. September. This is a very nice September. Hi, Gabriele. Good to see you. Ciao. Hi, Cristo.
Hi, hello.
Hello. Good to see you.
Hi, Gabriela. So, Federico Faroldi, he declined from participating, so we will have more time. I don't know if we can. I have made this schedule upon request by the organizers, so that it runs in parallel. But I think that we are going to have much time for discussion in the end of the sections, approximately 30 minutes or 40 minutes. So I don't know if it would be better for those who are going to present their work to use maybe 5 minutes in addition to this 10 minutes which is scheduled, or if we leave this for discussions at the end. Maybe it's better. Maybe the one who is going to make the speech may use the discussion time to present further ideas, so that we don't lose the parallel schedule with the other presentations with the other workshops.
Okay.
Hi, Nino. Now I can talk.
Hi, Gabriela.
Hi, Giuliano.
Mike was muted. That's the reason why.
Yes, it's only the host can allow people to speak.
I see.
Yeah, actually, there is Roberto Borhaus is the technical chair. He's a student of mine, very talented student, and now he's helping us with that. So Roberto is in charge of giving.
Let's try again. Okay. Now I think it should work, right?
Yeah, I think we are seeing your screen now.
Yeah, very good. Here we are, I think. Can you see the full screen presentation?
Yeah.
Okay, so when you say I can start, I start.
Yeah, so it's already recording. So thank you very much, Nino, for joining this conference. I would like also to thank all of the participants, all of those that have submitted papers. I think that we got a very nice workshop with excellent papers, and it's an interesting addition to the KR conference. I hope that this is the first of several others workshops on legal reasoning that could happen in the KR conference. So since we are tight with time in the schedule, I will give immediately the word to Antonino Rotolo from the University of Bologna to deliver his talk.
Thanks, Giuliano. Thanks everybody for inviting me. These strange conferences virtually, but I think I still feel, your warm participation. So, the talk of today is doesn't present new research, but is meant to offer some reports on some ideas I developed along the last few years on legal interpretation with other colleagues, in particular with Guido Governatori, my former student Alessandra Malerba, and also Giovanni Sartor. So there are some papers on that. I will just offer the basic ideas that were presented by the way, in some other conference like ICAL and URIX, but also in one journal paper. This is the outline of my talk. The idea is to offer a general logical framework for modeling legal interpretation, in particular, legal interpretation interpretive canons. The framework is based on a distinction which is well known in legal doctrine and legal theory, which is the distinction of interpretation as an activity or as an outcome. I will show that canons of interpretation in legal reasoning can be modeled as defeasible rules for modeling competing arguments and interpretive conflicts. I will show a couple of ways in which preferences can be used for managing for reason about interpretations. And I will also argue that in interpretation you may have different Deontic qualification. You may have obligatory interpretation, admissible interpretation, stuff like that. And then if there is time, I will show two possible ways in which the general idea can be developed. One in a very abstract framework, and another where the legal provisions have a structure, and then you work within the structural provisions. This is the outline of the talk. So let's start with some basic intuitions that are behind the framework I'm going to present to all of you. The first thing is that what I said has to do with the fact that we can distinguish between interpretation as an activity and as an outcome. But before doing this, we should define what legal interpretation is, right? There are many definitions in legal theory and legal philosophy. One definition is that legal interpretation is a process through which we ascribe a meaning to one or more legal provisions. So provisions are a piece of authoritative legal text, and legal interpretation is a process through which we ascribe a meaning to the legal provision, which means basically that legal interpretation can be thought as an act that maps a piece of text into a meaning. Some philosophers argue that this, in fact, is a way for paraphrasing a sentence into another sentence. But this is something philosophical. I don't want to enter here into the discussion here. You can just think of interpretation as a mapping between a text and the meaning, right? And that's something I think quite standard in legal theory. This view, the fact that the interpretation is a way for ascribing meaning to an authoritative legal text, means that you may have different ways you can ascribe the meaning, different ways in which you can ascribe the meaning. And the ways are in legal theory called somehow canons, so arguments for supporting a certain meaning ascription. For example, in a famous book on comparative law, comparative legal theory on the sources of law by Neil McCormick and edited by McCormick and Bob Summers, they identified 11 canons of interpretation, like, for example, argument for ordinary meaning, which means literal interpretation; contextual harmonization, which means basically argument by coherence, try to interpret a statute in such a way that the interpretation allows for being coherent with the other statutes in a certain part of the legal system. Then, of course, precedent, the argument by analogy, argument from substantive reasons, where you basically try to interpret the statute by promoting a certain goal of which is supposed to be, let's say, attached to the statute, or argument from intention, that meaning by that you should try to interpret the law according to, for example, the lawmaker intention. So the canons can be thought, in fact, as ways through which you map the text into a certain meaning. And you may have different ways to do so. And that leads to the distinction between interpretation as an activity and interpretation as an outcome. This distinction was defended in legal theory by many scholars, but I think that the first one who proposed this distinction in a clear way was Alf Ross in 1958 in the book on the main book by Alf Ross. And according to Ross, interpretation activity is in fact, as I said, as a way through which we ascribe the meaning, and the interpretation as an outcome is precisely the meaning that is obtained through a certain interpretive act, meaning by interpretive act, the canon. So the idea is that canons are nothing but interpretive acts according to the terminology of Alf Ross, proposed in the book on Law and Justice. So pictorially, you may think of provisions as units, and then you have a way through which, through canons, you can ascribe to the units some meaning, some interpretive outcomes. This picture shows that you may have two different provisions that mean exactly the same, right? The blue and the blue one and the green are, according to this, mean exactly the same, right? So two different canons or the same canon, depends, it leads to the same meaning. Okay, so basically this is the scheme in which, according to which we work with canons of interpretation. So consider this example. This is an example from Italian law, in Article 575, the Italian Penal Code. On homicide says that whoever causes the death of a man, so in Italian is chiunque cagiona la morte di un uomo, whoever causes the death of a man is punishable by no less than 21 years in prison. And of course, this doesn't mean that if I kill my wife, I will not be punished. But a man means uomo. A uomo is different from donna, woman. Of course, one could say, well, of course, you cannot kill your wife. Why? Because you have Article 3 of the Italian Constitution, which states that all citizens are equal social status, are equal before the law, without regard to their sex, blah blah blah. So you cannot discriminate. You cannot discriminate according to sex. So, in fact, this means that the piece of text that is formulated literally as whoever causes the death of a man should be meant as whoever causes the death of a human being, right? So you see the text, you see that through a certain type of interpretation, which takes into account another piece of the legal system, in particular the Italian Constitution, you cannot interpret Article 575 as allowing you to kill your wife, right? You cannot, of course. So this leads to understand how to formalize the canons formally. So canons are in fact rules, can be formalized as rules, and we think they are defeasible rules. So taking into account the example I mentioned before, you could say that if Article 3 ought to be interpreted literally, Article 3 of the Italian Constitution, and if Article 3 is related with Article 575 of the Penal Code, then Article 575 of the Penal Code must be interpreted by coherence as B. And B is whoever causes the death of a human being is punishable by no less than 21 years. So formally, you can capture the intuition this way. You have a rule capturing this interpretive argument, and if Article 3 of the Italian Constitution should be interpreted literally as D, and there is a relation between Article 3 and Article 575, then the interpretation by coherence of Article 575 leads to B. B, remember, is whoever causes the death of a human being is punishable by no less than 21 years, sorry. Right, so basically, we can formalize the argument in this way. Of course, you may have conflicts between different canons. take into account these. Suppose that we have the rule as above, as we already considered, and we have another rule that says that if you are not citizen, remember the Article 3 of the Italian Constitution says that all citizens are equal before the law. Well, we know, and there is another argument that we should develop, that in fact Article 3 doesn't mean citizen, means human beings in general. But this I cannot. Let's leave this apart. But suppose you are not a citizen, then we should interpret Article 575 in a different way, and B prime is incompatible with B. Okay, this is incompatible with B. Typical, which means that B, the negation of B prime is B, right? Or they are different, but they are incompatible somehow. The notion of incompatibility can be logical, but can be also non-logical. I don't care. We just establish a relation of incompatibility. Then you have to solve the conflict. There is another case, which is the following: B and B prime are not incompatible. They are simply different, but the argument is exactly the same: interpretation by coherence. This is in fact a conflict, because you cannot admit that the same interpretive canon, argument by coherence, applied to the same piece of legal text, can lead to different meanings. The same argument applied to the same legal text must lead to a unique result. So if we have two rules that state that two different results are obtainable, which means that you have a conflict. So this conflict is different from this one. This is a conflict where you have two incompatible interpretations using different arguments. Here we have two different but compatible interpretations that are incompatible because we use the same interpretive canon. And it doesn't make sense that the same interpretive canon can lead to different interpretations, right? So in both cases, we have conflict between two rules. And then the question is how to solve. Well, in defeasible reasoning, you may have a priority relation among rules. For example, we could say that rule R is stronger than rule S, and then means that we should obtain this, and we should refrain from obtaining this. So in this perspective, we use preferences for solving conflict. But you may have other cases where you may have situations where the preferences are not used for solving conflicts, but they are used to express ordering among different canons. This thing exists in many legal systems. In the Italian legal system, for example, this, right? Like this is the rule. In the Italian Civil Code, Article 12 says that in applying the law, judges ought to ascribe to statutes their literal meaning, an ascription that can be done by also consider the intent of a legislator. But if a case cannot be solved in this way, judges have to employ arguments by analogy, and when this is not possible, it doesn't remove all doubts, the decision ought to be based on the general principles of the legal system. So this article of the Italian Civil Code states that you have an order among canons, which states that judges should resort first to literal meaning, to the literal meaning canon. If it doesn't work for some reasons, then you have to move to other options. The second option is intent, then analogy, then general principle of the legal system. So there is an order among the different canons. There is now, of course, a matter of political interpretation of the legal system, but this is what happens. So we can formalize this in this way using an operator that I introduced many years ago with Guido in the context of contrary to duty reasoning, but can be applied also here. So you may have that. It's important to focus this rule. Was exactly modeling the case where you kill your wife. But then if you have this condition, then you should interpret Article 575 as B, as an interpretation by coherence, which is the first option. If this is not possible for some reasons, then you should interpret the same article as B as well, but using a different canon, which is this, for example, the canon of substantive reasons. If this is not possible for some other reason, then you have the last option, which is the negation of the literal interpretation of Article 575. So here you have a ranking, an order among interpretive canons which are not incompatible. You know, in one case you have the same outcome, but the point is that the law sometimes requires you to impose a specific canon as a first option, right? You know very well the reason why, of course, because you have the separation of powers, you know, and literal interpretation is, of course, the most preferred option because it reduces the discretional power of judges. So it's the first option. But suppose that how it works. Suppose that Article 3 of the Italian Constitution is revised, which means that the interpretation by coherence of Article 575 is no longer possible. Then you have an attack, this rule attack this option. It means that this is no longer possible, but you have the secondary option, which is this. So given this set of rules, you don't obtain this as an interpretation, but you can obtain this one, okay, the second one. Then let's see the Deontic qualification of interpretation. I said, I already commented this piece of the Italian Civil Code. These also suggest that we may somehow have a Deontic qualification of interpretation. The literal interpretation is sometimes obligatory, is the first option. So this means that you can say similarly for other types of interpretation. So in general, you could also say that an interpretation can be admissible or obligatory. Is admissible when you can prove it using one defeasible interpretation rule. It is obligatory if this interpretation is the only one admissible. And the same applies for outcome interpretations, not only for activity interpretations and activity. So basically, you have this distinction, and you can interpret, at least in what we did in our papers, we distinguished in this way, the two types of interpretation. So I can give the intuition of the proof theory, but I will not enter into the much details, but just to show briefly how it works. Then we have an interpretation theory, a set of facts, a set of rules, and the superiority relation, which apply binary relation applying to the set of rules of the interpretive rules we use to model canons. So the proof theory for the interpretation, I can show just a couple of slides on that. For interpretation as an activity, we can say that interpretation phi is admissible if the fact that it is admissible is already a fact, or a fortiori if it's obligatory. As a matter of fact, of course, if something is obligatory, then it is admissible. Or alternatively, the opposite is not a fact, and we have a rule proving phi, and such a rule is applicable, such interpretive rule is applicable, and all possible rules that are attacking, are supporting compatible interpretation are not applicable, or they are defeated by some other rule. Okay, so this is a standard way of proving defeasible reasoning in defeasible logic, for example, and that's the way in which define that the interpretation is admissible using such type of rules. When we move from admissible interpretation to obligatory interpretation, then basically we have that, this is exactly as before, but just focus on 2.2. We assume that the interpretation at stake is provable, is admissible, and there is no other canon that supports a compatible interpretation of the same statute. Okay, so we only have one canon supporting an interpretation which is compatible, which is the one we are considering, and there is no other canon supporting compatible interpretations of the same piece of text. Okay, so if we have that, then we say that this interpretation is obligatory, is not only admissible. Then you can apply also this to all interpretation as an outcome, as interpretation in terms of admissibility and obligatoriness of interpretation. But you know, the intuition is exactly the same, so we don't need to spend time. So I have 10 minutes left, so I can show you briefly how it works, the machinery. So suppose we have to kill, as a matter of fact, that someone killed an adult and killed a female. We have the obligation to interpret literally Article 3 of the Italian Constitution as D, but their Article 3 is revised, and we have a case of a non-citizen. And we have the rules that, according to which, if you kill an adult, you kill a female, and there's obligation to interpret Article 3 in a certain way, then you have this order of preference of arguments. Then you have that the Article 3 of the Italian Constitution is revised, then you can no longer interpret, as we said before, Article 575 by coherence as B. And if you are not citizen, then you have to stick to the literal interpretation of Article 575. And by definition, we interpret Article 575 not as B prime, as B. So, sorry. So here you see that you have a conflict. You have a conflict. Why? Because this rule, which is applicable, states that Article 575 should be interpreted as B by coherence, and this rule states that we cannot interpret by coherence Article 75 as B. So we have clearly a logical conflict. But then it means that we have this conflict, and this conflict is in this conflict, rule S is stronger than rule R. Then it means that this cannot be obtained. And then we have the secondary option. So we can interpret Article 575 as B, but not by coherence, but by substantive reasons. But then we have another conflict, because this rule attacks this. But W is stronger than T. So then this reinstates this interpretation. And in fact, what we obtain that the interpretation by substantive reason of Article 575 as B is an admissible interpretation as an activity, and also interpretation by principles is admissible. And as a interpretation of Article, there's no obligatory interpretation, because we have two possible interpretations, and then we have one admissible outcome interpretation, one obligatory outcome interpretation. Okay, Giuliano, I have other 7 minutes, right?
Yeah.
Okay, so I can briefly show just the intuition of a possible extension of the framework, very fast. Here we are handling before we handled proposition as non-analyzed proposition. So you have B, you have a piece of text which is B, and we have an outcome which is B prime. But you can apply the same intuition by manipulating the internal content, the internal structure of rules, of some prescriptive rules, for example. Right? This rule states that if you kill a man, then it's obligatory that you have at least 21 years of prison. Right? So before this rule was not analyzed. Before it was just a B, C, right, a proposition. So in this, if you apply the intuition as before to rules which are analyzed, then it means that the interpretation basically is a map that replaces some literals in the rule into the same rule with a different literal. So, for example, you could say that if I kill a man, and this rule, in the antecedent has this as a literal, but we can interpret this rule as differently, and which means that kill man is substituted in the new version of the rule by adding kill human and not kill man. So the same intuition as before can be analyzed, can be performed in such a way that you manipulate, which you change the internal structural rules in a given set of rules, right? So, which means that this interpretation, suppose you have a theory when you have this version of the rule, but you have this interpretation, which is, for example, admissible, then it means that if this interpretation is admissible, It means that you change the legal system and you replace this rule in the legal system by this new version of the legal system. Okay, I can skip the example by saying that is interpretation as norm change? Well, of course, is. Not like norm change. This is something that sometimes legal philosophers don't like. Legal philosophers sometimes prefer to keep a very clear distinction between interpretation and norm change, especially in continental law, especially in civil law systems. But in fact, if you read the interpretation in this way, the fact that you, in interpreting one rule, you are replacing text, and then you are substituting the old version of the text with the new one, it means that you are in fact changing the law. So from a logical point of view, there is not much different. Of course, there are differences, of course, but you know, the intuition is not so easy to, the distinction is not so easy to draw. We can draw it, but for example, by saying that interpretation is case by case, while norm change is not case by case, at least in continental law. But the logical process is very similar, at least if you view it from this angle. Some basic results, and then I finish. So I thought I still 3 minutes. Of course, it's quite easy to show that the admissible interpretation include the set of obligatory interpretation. The logic is sound, and the logic with abstract interpretation, not with structural interpretation, is linear complexity. So in other words, basically, the logic is a variant, a notational variant of standard defeasible logic. But I think this is a good thing, you know, because we can preserve the nice computational properties of the logic. For the other version, this, when you analyze the internal structure of argument of rules, you know, the result is not obvious. I think we can extend this. Because there are ways for transforming theories in a different way, but you know, the result has not yet proved. And I think this is the end. Thanks.
Thank you very much, Nino. Very nice presentation. I have some questions, but we are going to leave the discussion for the end after Christoph delivers his talk. So Christoph, now then I give the word for Christoph. He's going to present a paper which was written in collaboration with Dave Mayer and Bertrand Lomfeld. It is Encoding Legal Balance, Automating an Abstract Ethical Value Ontology in Preference Logic.
Can you see my screen? Hello?
Yes.
Everybody?
Yes.
And you can hear me well. Okay. Yeah, thank you very much for the opportunity to present this work here. So we have 10 minutes. We can't go into details, but we are really happy to present this piece of work, which is kind of, let's say, relatively fresh work. We are a team now. We created that team roughly half a year ago or 3/4 of a year ago. And this is consisting of Bertram Lomfeld from the law department. He's also in the audience and he will give part of this presentation. And it's myself and David Mayer. So myself and David are more working on the knowledge representation and reasoning side. And we talk a bit about that in the presentation here. And Bertram, of course, has this expertise and background in legal reasoning in law and in particular here in value ontology. So because what we are after is you see it, and the title was mentioned, encoding legal balancing on the computer. So when we want to try to get legal balancing, and when I mean on the computer, I really mean practically on the computer so that we can play and interact with running systems. And that of course has many challenges. In the first place, it has this kind of theoretical questions involved, namely, for instance, what I choose as an underlying logic for encoding the legal knowledge in the game, which particular value ontology I want to work with, how actually to encode that in the logic that we have chosen, how to interact with other legal or world knowledge, and actually which level of expressity are we after. So in the previous talk, we have seen lots modeling more on the propositional side. I personally think, yeah, whenever we can, we should, but I have my doubt that it will always be possible to stay just on the propositional end of the logic expressivity level here. So our solution is a kind of holistic pluralistic framework, which we showcase here in the paper in some way, and also utilize for the first time to support this legal balancing. And this allows us to do the modeling at different layers of abstraction and playing with these different layers of abstraction, modeling at these different layers of abstraction at the same time in parallel, so to say, until we reach a reflective equilibrium in the end, and and we are kind of satisfied with the result of our modeling. So our main contributions here are that we applied this approach from knowledge representation and reasoning, which I call universal metalogical reasoning, and the logic key approach. I say a little bit more about that in a second, for the first time to support legal balancing. And as a side effect or a side contribution, we have a new encoding on the computer of a preference logic, a quite rich preference logic suggested by Van Bentham and colleagues. Then contribution B is a first-time operationalization of a value ontology on the computer. And this is work by Bertram Lohmfeld. And this has been achieved in combination, of course, with that particular choice of a preference logic. But well, we think that that layer can be exchanged in further work. And then we use that, the combination of A and B to explain wild animal legal cases. Many of you know much more about than I do, actually. So I talk a little bit more about this part A, and then Bertram takes over. Universal metalogical reasoning. So that's a question about taming this logic zoo. We all know it. We are developing different logical formats. Maybe every day a new logic is appearing in this logic zoo. And the big question is actually how to get a hand on that on the computer. And our approach is as follows. So whenever I have an application in mind, say machine ethics or legal domain, like we're addressing here in the workshop, then I have certain logics in mind I want to work with, for instance, Deontic logics. But typically there are no implemented systems, and we work a lot in pen and paper, but I'm also interested in really pragmatically working with machinery. So what I propose here is to shallowly embed these logics we are interested in classical higher order logic, and this gives us access to a whole bunch of existing theorem-proving technology. Like when we use the Isabelle-Hall system, but we could use others, we have access to theorem-proving technology that has been developed over decades, and we have access to model finding and counter-model finding technology. And interesting story here is that in the end, these systems we are accessing are driven by subsolving technology. That's very cool. So under the surface of the systems, you very often find such solving technology. So, and in this project here, we worked as follows. We applied this logic key methodology. You see the article here in artificial intelligence, which explaining that in detail. And the only thing that's fixed in this methodology is the base logic call. And all the other layers are flexible, and these layers we simultaneously work with in the approach. So in the first place, we are interested in the question, what object logic do we want to work with? Here, for instance, Deontic logics or combinations of Deontic logics with other formalisms. And then on top of that, we want to model our domain knowledge and in the end, the concrete use cases. Now, in the context of this paper, we did the following. So we did choose a particular kind of preference logic, and the choice can actually be reversed and replaced by another one. And on top of that, we then introduced another layer that wasn't particularly relevant here. We modeled the value ontology by Bertram Lohmfeld. And then in addition, we modeled, of course, general legal and world knowledge before we then encoded and interacted and analyzed these wild animal use cases. And this is now for me the point to hand over to Bertram, who will tell us a bit more about his value ontology.
Yeah, thank you, Christoph. It's not only my value ontology, but it's the question of which model of legal balancing we were using. And we were mainly following, can you go to the next slide immediately, Christoph? We were mainly following, or I'm extending on Alexi's approach of a balancing theory, which is more or less saying that we have rules and principles as two levels or two layers. And the legal reasoning is seen as a practical argumentation with a two-level model of these two layers, more abstract and scalar value principles and more concrete binary legal rules as a differentiation in between these layers. And legal rules then are reconstructed as conditional preference relations between conflicting underlying value principles. Let's go into one small example. In the following scenario, the possibly implicit application of a rule R involves balancing value principles A, which is here security, and B, freedom, in a context and under some given situations. And that could be like the following: in view of events E1, here a virus pandemic occurs, and E2, voluntary shutdown fails or other means fail. That could be a rule within, for example, the German pandemic code or a pandemic ruling law. Countrywide lockdown becomes sanctions since health security outweighs freedom to move. So you could display the relation in between the two principles by this formula. The rule under certain conditions, under this rule, then principle A outweighs principle B, which acts also as justification for the rule's legal consequence. And now we tried to model that, next page, Christoph, with Van Bansam's preference logic, this legal balancing logic, and tried to do that into the computing. But one substantial question remains, and that is my main topic of research. That's the next slide. Which values to use for balancing? I mean, in fundamental law, that's quite obvious. Alexei just took the fundamental rights of the German code and was saying, well, these are the principles. If you're going to other domains, that's not so obvious. And what I try to do in the last 20 years of my research is to look in different legal and ethical value ontologies and to make up a quasi-universal picture of value ontologies. And that's the following: opposing freedom and security and equality and utility, and trying to make a more concrete level of principles on the middle level. And the idea was to apply this value ontology and to encode that. And this value ontology can also consistently cover existing value sets from formal argumentation and IA and law accounts. You all know that Trevor Bench-Copon is here himself. He also used some of the values which appear in that value ontology. And and this is now the idea to encode that. And I hand back to Christoph to say a few words what we did for the encoding models.
Yeah, you see, basically our time is over. Therefore, I invite you actually to ask questions about that. I could even give you a live demo now about our encoding, because all of that, what we have written in the paper can, of course, be demonstrated with the machinery. And so you see here what we did. In the first place, we encoded the preference logic. Then we did some preference logic tests. So don't look at the details here, just to give you an impression how that looks like in Isabel Hall systems. Then we encoded on top of that the value ontology. Then we had some value ontology tests. And here I want to have another short remark.
Christoph, sorry to interrupt. We will have time for discussion now. I would propose to give you for more 5 minutes so that you can show how it works.
Yeah,
and
well,
then we discuss.
I'm happy to do that. Yeah, let me. Okay. Yeah, then that's excellent. Then I can open in a second the prover. Yeah, what I want to say here, that slide is, and I can demonstrate that also in a second, is that it's extremely valuable for these kind of modeling tasks where you in the very beginning don't exactly know what you are exactly after. So whether you have chosen the right logics and so on, so that you can really interact with the system. And here you see interaction not only in terms of proving theorems and confirming that your the things you want to prove indeed can be, but you also get models or counter models, and they are extremely helpful because you can read them, you can interpret them, and they help you extremely to sharpen your your intuition about the modeling in the computer system. So this is, for instance, a simple model that you get when you ask the system to give you an interpretation of this modeling of the value ontology, and then you can check with the expert, for instance, in our case with Bertram, whether he agrees with the intended outcome or what is shown by these models or interpretations, so to say. Well, we went on and modeled a little bit of general world knowledge as far as we needed, and then we encoded these cases, wild animal legal cases. Here the Pearson case, and there are also one. This is actually a point where I can show you now something running. Can you see that? This is the Isabel system. And here, that's exactly what the encoding now of the Pearson case. So we have some facts that we assume in the scenario. We also assume consistency in the values of the plaintiff and the defendant. You can see we can even distinguish that, make consistency statements of the value systems of the plaintiff and of the dependent, and they might be independent of each other, and inconsistency in one of them doesn't lead to global inconsistency in the system, and so on. And now we can actually formulate these lemmata here. For instance, the first one says, if we assume the Pearson facts and we assume that the value system of the plaintiff is not inconsistent, and the same for the defendant, then it's possible to explain that a decision for the defendant is compatible with all these assumptions. And the nitpick system gives me a model for that. And you can expect that model. It gives you all the details, and you can go and interpret and sharpen your intuition by looking at these kind of presentation here from the Isabel Hall system. The same now can be made for a decision in direction of the plaintiff. So also this would be consistent with the assumptions. Pearson's fact, not inconsistency value system of the plaintiff, and non-inconsistency of the value system of the defendant, but you can still have models that would say, yeah, a decision for the plaintiff is possible in this situation. So nitpick tells you that. But actually in the case of the Pearson facts, the only thing that's really provable now here is a decision for the defendant. And that is possible then with the theorem proving technology. So if I call here the prover, then it will tell me after a while, hopefully my machine here is fast enough, that it can prove that. It runs a bit and then comes back after some time with a result on these examples. So this is extremely, here we have another counter model. Sledgehammer is still running. Well, sometimes it takes a bit longer, we might come back to that. But you see here the generated proof already in short form by the system.
Resume, Christoph?
Yeah, I think I should not do too much. We can have it in the background. I can come back in a second. And I would jump now simply to the conclusion here. And then we can still look at the presentation or the demo if you want to later on. Just ask me about it. Conclusion and remarks. So our contribution here is a feasibility study in legal balancing on the computer. We demonstrated here first-time formalization in use of the value ontology contributed by Bertram Lohmfeld. And we also demonstrated how this logic key methodology and universal metalogical reasoning in Hall can be put in practice. And this is supporting, as I advocated, flexibility and expressiveness and ready-to-use ATP support. So it's an interesting tool for all of you. And my meta-level question here is actually why the knowledge representation and reasoning community has largely neglected the virtues of Hall so far, because implementing all these C improvers for these many logics we are developing is, in my opinion, not really an alternative option. And well, there's here related work by the organizers of the workshop. That ECAL paper is very much also in spirit of what we do. They use another logic underneath, and we could discuss more about these relationships in the discussion part. Thank you.
Okay, thank you very much, Christoph. Very interesting, and I see a lot of potentials of a discussion and also relation with the work that I have started with Giovanni more recently. And I have two points and comments to start the discussion. Maybe these are points not for 15 minutes of discussion, but we can use the other sessions, because in the other sessions we will have more or less 40 minutes of discussion, so we can get back to this point. Yeah. So the first one, which is related to Nino, which is one that I believe it's a fundamental challenge of understanding of the phenomenon of interpretation and modeling it, which is the distinction which is usually made by legal theory between the linguistic interpretation, which means, which is basically what Nino tried to model, which is the ascription of meaning to texts. And the other part of the interpretation activity is what is called legal construction. So, and that means making changes to address some what was defects on the law. By that I mean filling gaps or solving contradictions and etc. So these are conceptually two different dimensions, but what you see in practice is that they are intrinsically connected, and it's sometimes very difficult to distinguish them. In Nino examples, this was clear. So first he used the defeasible logic to model argumentation about ascription of meaning. But in fact, as Nino also acknowledged, there were changes in previous presentations or outcomes of the normative system. So you can model it both as an argumentation about meaning ascription, but you can also model it as a process of normative change. So I think it's a fundamental challenge to understand and try to connect these ideas. I mean, the representation by argumentations about meaning and the representation as normative change of the normative system at each step of this activity. So you may have a discrete representation, but also a representation on an argument, defeasible argument framework. I think that we should think carefully about that, because maybe there are situations where it is better represented as normative change, or and situations where the argument is would be better. I have further considerations about this, but maybe we can come back in the other sections. For instance, I think that Bobbio has some very interesting insights in a paper which is written in French, Le Bon Législateur, where he tries to describe what is the rational legislator with criteria of interpretation. But maybe we can come later on that. And another challenge, which is related with with Christoph's paper, is well, I can see clearly, and I believe your model is quite interesting. It's very important to relate models of balancing values with inferential machinery, so that you can have Deontic outcomes out of an inference about these values, which you can compare with legal obligations, for instance. And this is the track that I'm pursuing with Giovanni Sartor. So it's immediately to see that you may also adapt your theorem prover to work with, you already have papers using the theorem prover for input-output logic. So it would be interesting to see how it works there. But I think that a fundamental challenge that we should address is we have these proposals, mine and Giovanni, yours with Bertram, to try to balance in Alexis' conception, to balance different values and access their weight and see what prevails. But actually, if you see the practice in constitutional courts, there are some arguments that seems and looks like balancing, but there is another activity which is sometimes called, mainly in the German constitutional court, as a derivation of fundamental rights. So for instance, there is the derivation from privacy, the value of privacy, and from the value of free speech. In the census cases of 1983, they derived an important fundamental right, which is the fundamental right of informational autonomy. So that means it's not just balancing, choosing the one who has most weight, but generating another more specified principle. And I think that this is a mystery. How could we model that? And I see that Bertrand has this model which starts with high-level principles and then try to derive. So I think that we should put our energies to try to model and to understand what is this, what does jurists mean by a derivation of a fundamental right, or a derivation of a lower level principle, which is applicable to a particular case. So I think that these are very important issues in modeling legal interpretation. Okay, these are my points.
So just to comment on that, so that you're pointing at a meta system here that should be taken into account, which is telling us which parts are kind of considered as fixed and which parts are kind of open to more free modeling, or yeah, more flexibility. And it looks like this could eventually be approached by considering highly structured knowledge representation machinery in the background, which would provide you these different layers and tell you what is actually being allowed to be modified and changed, and what we should consider as basic fundamental principles that shouldn't be touched.
Yeah.
Yeah, my comment in regard to what you said is that you're right. I agree. We didn't consider it. We didn't consider explicitly construction because we wanted to model statutory interpretation. So you have a piece of legal text, and then you. So it's a precise way of thinking about legal interpretation, right? Which is very continental, I would say. Mm-hmm. But I agree that you know, there is a broader perspective, and even within the statutory interpretation domain, you see exactly that there is not much difference between construction and interpretation. You know, this distinction between interpretation and construction is performed by lawyers and by politicians and those who are policymakers, because it's clear that according to the doctrine of separation of powers, you need to keep clear what make law and what they apply law, right? And this is a robust and sound distinction from in general for policy reasons. But as a matter of fact, the distinction is very subtle.
Okay, There are lots of questions here. They are also asking if I'm seeing the questions. Yes, I do. And it's not only the chairman which is allowed to ask questions, of course. I'm sorry that I have advanced my questions. So Trevor has a question, also Nico Potka, I believe, Giovanni Sartos, and also Reka Markovic. So I don't know if we have time for all of them, but as I said, we are going to get back to these points in the other sections. So Trevor.
I will put mine in the chat so you understand it. Can you read the chat? It's just here there, is that? Yeah. Christoph should answer this. He should put his microphone on.
Your
question in the
microphone,
chat.
Christoph.
Yeah, maybe David, do you want to comment on that?
Well, in the case of Pearson, I don't quite recall right now details, but Pearson was the guy who was hunting the fox.
Yeah.
No, the guy who found it. Yes, Pearson win because there is a preference for legal certainty, which is the complete instantiation in this case of security, legal security, which has a preference over the value that in this case helps in the post, which was, if I recall, his freedom, because he was pursuing like freedom to carry out his livelihood.
Yeah, here we have the different here, for instance, here's a proposed argument, and then you can try to ask, can you see that again, the slide?
Yes.
So then you can also ask what your preferences in the current situations are, and those are actually then influencing who is going to win and who not. So how these preference relations here are kind of given in the current situation. And
stability, yeah.
Yeah, and in this case, here in the pro-Pearson argument, did we do that here? I don't find it displayed here, but in the proposed argument, we see it here. I mean, we would then change by this axiom the relationship between stability and
efficiency.
Efficiency.
I mean, it was on the one hand side, it's the freedom. On the other hand side, it was the efficiency in that sense that it is good for the whole economy if foxes are hunted. That was one of the arguments which the judges also advanced.
I know the
You know it. You know it.
I just wondered how you match the values I know to the values you use. And
legal certainty becomes stability in the ontology, right? That's it.
Right, and we have access to that and can of course play with those preferences.
Yeah, and do you have these preferences in some precedent so that you can reason with precedent?
Again, I didn't fully. I have to get.
I'll put it in the chat.
I mean, precedents are giving you different preference relations in between the values. And so you could argue and saying, well, no, this is not the preference relation, the conditional preference relation, which should outweigh the others. But a precedent is giving you another preference relation. And therefore, if we then modeled after the Conti case, we used Pearson as a possible precedent for the Conti case and showed if we use that as a default option, then it will solve the Conti case in this way. And as we have to argue against the default setting, so to say, of the precedent of the Pearson case. So that's how we
Okay, thank you. I'll read the paper that I mailed.
Yeah, so just a comment, all the details of the modeling are in the end in the paper. So we included all the information. So the screenshots are complete in that sense. So if somebody wants to look at that, that should help to eventually get some kind of intuition on how this works in the end. But maybe we could, I mean, that would be something, prepare a longer tutorial session or step-by-step and look into that, but we need some time for that because it's kind of very layered modeling we in the end have to look at. Yeah.
Thank you.
Okay, thank you. We have 20 minutes of coffee break, which is now 16 minutes, no, 18 minutes. Or no, 16 minutes. So I don't know. I don't know how the coffee break works. Renata has told me that there are some rooms of coffee break. I don't know how it works. Maybe Roberto has discovered how that works.
Why don't we stay here?
Or we will stay here and move forward to Rekka's question.
I think that's what I would prefer.
Okay.
If people want coffee break, they can leave.
Okay, Rekka, would you have the word
Happily.
now.
Yes, okay, thanks a lot. So I was wondering about Nino's example, whether I would be reluctant to accept it as norm change. Coming from a civil law system, of course, my first reaction is that no way, of course, it's not norm change. But I'm not completely sure about that because, for example, the Hungarian system has a solution for this kind of resolving this kind of interpretational conflicts by the Supreme Court. And once they say that this is to be interpreted as this way, maybe that is very close to norm change. But regarding the specific example, I wanted to ask from Nino that isn't it the case that when the civil code was phrased by the first time, maybe in the Napoleon era, I don't know, but for example, ours were first. So isn't it the case that the use of that word described all human being, and this way assigning the current meaning of human being to this word is just restoring or reconstructing the original meaning. So it's not change at all, but ensuring the original change. But I don't know, because you didn't mention any kind of historical or linguistic argument in this sense that the use of that word was different than it is now.
Yeah, first of all, what you said in general, you know, of course, the distinction between interpretation and then non-change, you know, is a very subtle issue, right? It's not by chance that this distinction is somehow fuzzy if we start with the assumption of the Ralph Ross theory, which was a realist, and for him there was not much difference between interpretation and lawmaking. So you can have different theoretical assumptions. Probably you can draw a sharp distinction, but you know, so it's a matter also of theoretical assumptions, right? That the theoretical assumption in the papers were this, and of course, you know, regarding what you said, you know, the example when I use the term uomo, I mean, and then in the provision is not from Napoleon time, is much more recent, and I gave the possible interpretation, which is based on the Italian interpretation, right? Italian constitution, right? But it was just a toy example. You may have other type of reasons why, but still, the penal code, the Italian penal code, still states use the term uomo, right? Of course, at that time, uomo was meaning human being, because you know, there was not gender balance, gender sensitivity to the language at that time. So you're right. It could be that the original intent was exactly to mean, but this is exactly another canon of interpretation you can apply in order to state that uomo doesn't mean uomo. Uomo means human being. Yeah. So I didn't mean to propose the correct interpretation of the Italian Penal Code. I will simply show there are ways, different canons you can use to interpret the text in this way or that way.
Yeah, I absolutely understood your proposal. I was just wondering whether this example supports the norm change parallel or not.
If you think that, well, also everything, it depends on what you mean by literal interpretation, right? Literal interpretation, that is very, as you know, is a very difficult issue, right? Also from a philosophical point of view. But if you stick to the fact that literal interpretation is A, independent of what A is, and the result of interpretation is B, and then you replace the A version with the B version, that you are logic, you have norm change. If by norm you mean the meaning of a provision, not the text, because this is also a clear distinction in legal theory, right? The norm is not the text, the norm is the meaning of the text.
Yeah, in this case, what happened then, if it's true what I'm saying, that it might have been the original meaning, is that restoring the text to the meaning?
You can say that using a certain canon, you have a certain meaning, use another canon, you have a different meaning. And then you prefer the other meaning, that it means that you are changing the law, according to this view.
Yeah, but now we might have changed the text in order to have the same meaning.
Exactly.
But, okay, well,
exactly,
okay, good question. Thanks.
Thank you.
I believe that Giovanni has a question too.
I'm listening. He's listening.
Unmute, Giovanni. We cannot hear you.
Yeah, your microphone.
Mute. Okay. No, I think that people are entitled to have a few minutes of rest before going into the next session. I was just pointing to an issue that may be interesting to think about. So we have in both presentations, we have preferences. In both presentations, we have obligations. And it would be interesting to see what happens with a deontic logic based on preferences. And then maybe the two approaches can be merged. This is something I'm also be thinking about, and also working a bit on that. So I think it would be an interesting direction to go. I'm sorry, just stop here.
Of course, I agree, Giovanni. I agree with you. But I don't know if my agreement has a value, right? But of course, I agree.
Yeah, I'm generally arguing for more experimental work. Not that I'm against theory, not at all. I come from theory as a background, but I think it's in particular in this area, there are so many interesting questions which in the end call for experiments in combination with theory. And we could do more in this direction. Yeah.
Okay, so how much time do we have until the next session, Giuliano?
10 minutes.
10 minutes.
So maybe I suggest that everybody relaxes, get a coffee or something, and then in 10 minutes we are back here for the next session. So I would like to thank everybody. This was an excellent session. I still have further question that I would like to pose to the presenters of these two great presentation. I think it was also interesting that they were somehow related. But okay, let us see. Let us meet again in 10 minutes.
Okay, so thank you very much. See you then. We come back in 10 minutes. 9:20. I mean 2:20 p.m. Okay, it's 19:20 is Brazilian time. Okay. Okay, I started recording again so we can come back to our second section. We are going to start with a presentation by Gregor Benck. The title is Formalizing German Legal Opinion as Planning.
I hope you can hear me, everyone. So, okay, Nico. not so. What I was interested in this paper is not so much legal argumentation, but so not the process of determining the meaning of a piece of law, but deriving consequences of a once fixed interpretation into a specific situation. So take as an example the following situation where we have person blue who goes to person green and buys a set of tiles from him with the stipulation that these tiles should be white. He gets a box of packed tiles, goes home, unpacks the tiles and sees that the tiles are black. Then he of course returns to person blue and says, well, I bought white tiles from you, but I opened the box and they were black. Now green says, well, so you took the tiles without checking them. I don't want to do anything about it, just stick with your tiles. In usual situations, so in courts, but also when you're training as a law student in Germany, you're of course asked to derive the legal consequences of such a situation. For example, in this case, of course, the green person has to provide the blue person with new tiles. So this is one consequences among a lot of them, and the question is, how do we actually derive them? In the German legal system, we use, or what law students mostly use, are so-called opinions that are a structured way to derive legal consequences from the specifics of a case. Or more technically speaking, there are not to derive legal consequences, more to check the presence of or check whether a given so-called premise, a statement of law, is actually true for the given situation. So for this case, a possible premise would be something like G may have to provide new tiles to B, and then the opinion is a structured piece of argumentation that tells you why why this claim is true or not true. The opinion, or the general structure of opinion, consists always of 4 steps, starting with the premise. After the premise, we usually provide a so-called definition that states the conditions under which this premise is true. So in the case that G may have to provide new tiles to B, this is the case if B has a right to supplementary performance, among other things. It's just a simplification at this point. Now, the statement of a right to supplementary performance, again, is a let's say non-primitive claim, which has further definitions in the legal system. In this case, we go essentially one step into the hierarchy and say, well, B may have a right to supplementary performance. We're essentially starting an inner opinion with a new premise. Again, providing a definition for that. This is the case if B and G have a sales contract. The object in question has a defect, the risk has passed, and there is no preclusion of the right to supplementary performance in this case. Again, these 4 conditions are non-primitive conditions. So we, again, have to check them in kind of a hierarchical fashion. So we have to start checking first whether B and G have a valid sales contract. This, again, involves a lot of argumentation. And in the end, we obtain a result, in this case, that B and G have a valid sales contract. And then we proceed on to the second point in the definition here, which is that the object has a defect. One reason, among others, is that the defect, or an object has a defect in this case, if it has not the agreed upon quality. Now we come to the 4th point, because again, a simplification. Let's assume that this is a kind of primitive statement of law, which we can actually check against the specifics of the case. In this case, B and G have agreed that the tiles should be white, but they are black. This is something that I don't want to deal with here, or I didn't deal with in the paper, because I think this is more of a question for natural language processing or machine learning problems, because it involves analyzing what essentially is in the case that you're given, what are the circumstances, and how do we map them to the actual situation that we're in. Say the object has a defect, and then return back with our results and say that, well, B has a right to supplementary performance and G has to provide new tiles to B. why am I considering opinions? Well, they're kind of a very structured way of thinking about legal problems, this kind of four-step and providing hierarchical structures. They are a very logical way of thinking about legal problems, and they are essentially the way how law students are actually trained in Germany. So especially almost all exams that you write are ask you to provide an opinion for a specific case and a specific claim. The question is, how do we actually come up with these opinions, or what's the most standard or most frequent way of doing so? Well, for most cases, especially in civil law, you have for most types of claims so-called schemata, so that there are actually books on containing these schemata, and books that use for teaching actually contain schemata, for example, for the question of a defect, which says, well, if you want to check whether an object has a defect inside of an opinion, you have to check these 7 things, not agreed upon quality, and then so on and so on. And it provides usually a logical connector between all these elements. So in this case, for a defect, one of these 7 things suffices. So if it has been wrongly assembled by the vendor, then the object has a defect. But there are also other connectors, like things where you have to check all conditions. For example, the one that we've seen before, where you have the right to supplementary performance, you have to have the sales contract and the defect, and the risk has to pass, and you have to have no preclusion. Well, based upon this kind of hierarchical structure, I looked at the similarities of the structure with what's called a total order hierarchical task network planning. A bit of details here. In this kind of formalism, we distinguish 2 types of what we call tasks or actions. The primitive actions are those that essentially don't need to be refined further. We can execute them directly, while compound actions need to be refined further. And for that, we have, and our objective is what's called initial abstract task. We want to execute a specific task. And for that, we have decomposition methods that tell us, well, in order to do this task, you need to perform one of these sequences of other actions or tasks. Select one, then replace the task with the subsequence, continue this until you've reached a sequence that contains only primitive actions, and then you can actually check whether you can execute it or not. The point here is that these 2 formal opinions or legal opinions in the German legal system and these HDN planning problems have a lot of similarities in the sense that claims, for example, claims in an opinion correspond to abstract tasks. There are things that you need to possibly refine in order to determine whether they are true or not. So you could formulate something like, as X has to provide new tiles to Y, as an abstract task must provide X, Y, and new tiles. Subsumptions kind of correspond to primitive actions because you're not have to refine them further. You just have to check whether they are true or not. Again, subsumptions involve natural language argumentation and so on. But here we are abstracting away from that. So you can say, well, subsumption on the fact that X might be white could be something like primitive action check property X has the color white. The facts of the case correspond somehow to state variables, namely, for example, that X is actually white. Then the primitive action check has property, it just has the precondition that the property is actually the color white. And a schemata, which provides you with a sequence of things that you have to check, kind of corresponds to a decomposition method. How does this look, and what do we have to think about here? Well, the schemata
Gregor, sorry, we are already in the limit of time.
Okay.
But I think that we could do like this. We stop now, we go, then we move to the other presentation, but we are going to have 40 minutes of discussion. Okay. Actually 50 minutes of discussion. Then you can come back from this point, and then we go to the session. Okay. Is that okay?
Yeah, sure. Sorry for taking too long.
No. It's actually, we are too tight in time, but we can use this time of discussion, which will be longer because Federico Faroldo is not going to present his paper. So
okay. I'm shutting off my screen share then. So
yeah, so then I would like to ask Inga and Nico Portica to to take the word and present the paper Explainable Automated Reasoning in Law Using Probabilistic Epistemic Argumentation.
You're muted, Ingo.
Sorry, my screen share is a bit off. 1 second. Can you see my presentation now?
No.
Okay, good. So, yeah, hi, my name is Inga Ibs. I'm currently doing my PhD at the Technical University of Darmstadt. And together with Nico Potica, who is at the University of Stuttgart, we looked at the feasibility of using probabilistic epistemic argumentation for explainable automated reasoning in legal trials, or for evidential reasoning. So our main objective was how to formalize uncertainty and legal assumptions of evidential reasoning in a criminal trial. Since we view a legal trial as a collection of evidence and hypotheses, and in this case, the legal decision maker have to weigh evidence in the trial. And there's an inherent uncertainty about the plausibility and the relevance of the evidence on the hypotheses of the trial. And we wanted to formalize those assumptions and beliefs for more transparency of the legal reasoning process. And we wanted also to use recurring reasoning patterns like presumption of innocence, inculpatory and exculpatory evidence, and others to actually, on the one hand, make the framework more comparable about a variety of cases, and on the other hand, to allow more expressive explanations. So as a basics, we took the probabilistic epistemic argumentation framework, which is based here on a bipolar abstract argumentation framework. So we only consider the relations between arguments, not the individual content of the arguments. The arguments are labeled with probabilities, signifying belief in the argument. And on the right, you can see a small example for this framework. So we have one attacking argument, which is T1, one supporting argument, which is T2, and both have assigned beliefs here in this framework. And we have one argument of innocence where these two arguments are related to. And then we can define constraints, which give us our semantics in the framework. So two example constraints are coherence. Coherence means that our belief in an attacked argument is bounded from above by the attacking argument, and support coherence, so that the belief in a supported argument is bounded from below by a supporting argument. So in this case on the right, T1 would provide the upper boundary in the belief in innocence, T2 would provide the lower boundary in the belief in innocence. And if we restrict to linear combinations of these atomic belief statements, then we can ensure polynomial time computability. So two reasoning problems are included in this problem. So one is the satisfiability problem we want to solve, which is, are the constraints that we defined and the probabilistic labelings we defined actually satisfiable by a probability function? And the other one is, if it's satisfiable, which bounds are entailed, which is called the entailment problem. So in this case, this would, if you look on the right, this framework is satisfiable with the prior initial probability statements of 0.2 and 0.7. Since those beliefs are actually consistent in this case, they can be satisfied by constraints. And the bounds that result are 0.7 to 0.8 for the corresponding probability function for the argument of innocence. So as a basic legal argumentation framework, we propose an argumentation graph which consists of a finite set of arguments, including three meta-hypotheses of inculpatory evidence, exculpatory evidence, under which other hypotheses can be grouped and evidence can be grouped, and the argument which is kind of the ultimate hypothesis of the innocence of the defendant. Then we have a finite set of directed edges between those arguments and an edge weighting function, which actually denotes a weight in the rational numbers to each edge between arguments. So for supporting arguments, we in general say that the weight has to be between 0 and 1. And for attacking arguments, their weight has to be between -1 and 0. And then we define a set of constraints, which we call weighted coherence and weighted support coherence. So weighted coherence means that the belief in an attacked argument is bounded from above by the weighted belief from the attacking argument. And its support coherence, weighted support coherence means that the belief in a supported argument is bounded from below by the belief in the supporting argument. And the belief in innocence we determine by its belief's upper bound. So we take the maximum possible belief in innocence, which is an implementation of the presumption of innocence. So here's a small example to show you the dynamics of the framework. In this case, we have, you consider a case of hit and run driving. We have 3 items of evidence. One is the plaintiff witnessed the accident and denoted the license plate, which is T1. It's a supporting argument for inculpatory evidence. Then we have also camera evidence, which shows a person looking like the defendant, which is E1. It's also grouped under inculpatory evidence. And then we have a third item of evidence, T2, which is that the defendant provides an alibi. And this is grouped under exculpatory evidence as a supporter. And we can see the edge weights at the edges. So for T1, we say that the edge weight is 0.9, which kind of means that we believe if the argument is plausible, then it should have a reasonably high impact, but not the strongest impact of 1, since, for example, the plaintiff could have made a mistake in this case. But for the camera evidence, we would say it has a very strong impact if it's plausible. So in general, the belief in an argument signifies the plausibility of the argument, and the weight of the edge signifies the relevance of the evidence or the argument on the related hypotheses. And we define also an acceptance threshold for the guilty verdict, which is that inculpatory evidence belief has to be higher than 0.9, such that we believe that the defendant could be guilty, and we report this back in the explanation. In general, we would say an argument is accepted if the belief is higher than 0.5. So this is a higher threshold for the presumption of innocence again. And here we have an example for belief assignments in the framework. We see T2 has a belief assignment, and this information propagates through the graph. So T2 provides a lower boundary for exculpatory evidence, since it speaks for the innocence of the defendant, and in turn provides also an upper boundary for inculpatory evidence, which gives us feedback about what beliefs are consistent with our initial belief statements, since we can't believe inculpatory evidence more than we doubt the exculpatory evidence. And we can only deduce a maximum upper bound for innocence, so 1. So our automatic explanation would declare that the defendant is declared innocent due to convincing exculpatory evidence. And then another example where we assigned a relatively high belief statement to the camera evidence, and we see how this information propagates to the graph again. This actually provides an upper bound for exculpatory evidence, but also for innocence. And in this case, inculpatory evidence actually meets our acceptance threshold. And this can be declared in the explanation. So in the explanation, we would state that the defendant is declared guilty due to convincing inculpatory evidence, since it meets our threshold. But also we can go low on the graph, look at the maximum induced to support, and look which argument is it. And this is given by the convincing camera footage in this case, and we can report that back. So in general, this framework can be extended for more legal patterns or reasoning patterns. We derive from the work Fenton and Neal did in 2013. And also collective support constraints can be added for more complex patterns of evidence, for example, for motive and opportunity, or for dependent evidence, where only the collective support of both arguments should be counted in the framework. So in conclusion, the reasoning assumptions can be explicitly stated in the framework, and legal principles can be incorporated in the semantics. Automated explanation generation is possible and is valuable feedback in this case. And in worst case, we can provide polynomial time computability. However, in future works, one should look at the beliefs and weight elicitation for the framework, and also in the interpretation of the beliefs. And then also on the inconsistencies, since in this case, if we assign inconsistent belief statements, the framework fails. However, this could actually be an advantage of the framework, since one could look at the sources of inconsistencies and report them back, and also look at the severity of inconsistencies and report them back. And that's work that's actually done for abstract argumentation in general. So this could be applied here. And also more complex combinations of evidence should be modeled in the framework, which in turn could mean that we can't ensure polynomial time computability anymore. So yeah, thank you for your attention. Do you have any questions?
Thank you very much, Inga. I would suggest to come back to Gregor so that he can finish his presentation. So then I open to questions about both presentations.
Okay.
Thank you.
Again, sorry for taking so long. This is actually quite quick here. So the last remaining thing that we have to do is actually to represent these schemata, which provide sequences of claims that we have to check in order for a master claim to be true, to be modeled inside of a decomposition method, and of course the logical connector. This is relatively easy if it's a conjunction, because if you have a conjunction, but all the three if you have a claim and three subclaims and a conjunction between them, of course, all these three subclaims have to be checked. So you can just have a method with these three tasks in there that represent the respective subclaims. But that's a bit more difficult if you have a disjunction. Just ignore the word free here for a moment. If you have a disjunction, it's essentially sufficient to show that one of the claims is true. So you just need one of the tasks in the method. But then there are also things, or at least in schemata, if you're writing opinions at some point, there is a distinction between different kinds of disjunctions. In some situations, you can just argue for one of the elements of the disjunction, but in other situations, you have, as shown in the talk by Antonio, in the beginning, you have a kind of a precedence relation between the subclaims. So you have to check the first one. If it's not true, then you only are allowed to check the second one. So you actually have to include these this kind of order, and if the first claim isn't true, have to include its negation somehow. Then there are situations where you actually have to check all of the elements of the disjunction, irrespective of whether one is true and the other ones are false. This is, for example, the case in penal law. You have some situations where you actually have to have multiple causes for a specific event, and you have to check all of them. One suffices, but you still have to check all of them if you're writing an opinion as a student. So what do you have to represent inside of the methods? Well, we have to somehow deal with negations. We have to deal with the logical connectors that we use. And if we are progressing through the method, we actually have to know how what the current state is. Have we actually in a disjunction found the element that is true, or haven't we? For that, we essentially split the modeling in two parts. We are introducing essentially shell methods that contain, the CMAS methods contain only shell tasks. And these tasks have, the shell tasks have two methods. Either we are actually checking the claim, or we do nothing, essentially not letting it be contained in the opinion. And the choice of which method we take is depending on additional state features that we introduce for checking whether we are in a in which state of the logical connector that we are in. So which connector do we have? Was the checking so far true or not? And what's the target that we have to check? Should we check it positively or negatively? And as an example how this works, assume that we have to check a claim A that is true if B, not C, or D are true, and this is an order disjunction, and B, C, and D do not hold. So in this case, we have to check B, say, well, it doesn't hold. Then we check not C, C, well, not C does hold because C doesn't hold, and then we don't check D. These will be two lines of tasks in the end. So what we would have in the beginning is we say, well, if we want to check B, we are prior to that in a mode, say, we want to check that B doesn't hold, because we, in the end, know that this is the case. and B says, well, this is actually true, I don't hold. C says, I also don't hold. And for D, in the end, we are in the mode done, which says, well, D shouldn't be touched at all, and we shouldn't write anything about it. Then we add to the method these invert tasks around C, which says, well, in the checking of A, we actually have the case that not C will be true. So we're entering it with the mode yes, then we invert it because C is negated here in that schema. We return, say, well, the result of C is actually no, then we invert it back and say, well, the result's actually yes, and we are in the mode where we say, well, the conjunction is actually yes. And then we add these set mode actions to the method that set the correct checking mode and ensure that the logical sequence is actually correctly checked. And then we have start mode and end mode, which set the first and the last mode of the sequences correctly, and we can use the hierarchy to essentially have a kind of stack of memory which checking modes that we are in. Yeah, so this concludes the talk, and I would be happy about any questions you may have to that. Just stopping the screen share.
Thank you very much, Gregor. So now we have time for discussion until 3:30 p.m. Is that right? No, until until 3:30 p.m. So does anyone have a question? I see here Trevor have a question in the chat. What is what does viewing it in terms of planning? This is for Gregor. What does viewing it in terms of planning give you over a simple backward chaining expert system?
Essentially, there are things, so you can, if you have modeled it in this case as planning, you can use techniques that were developed or are developed in planning, for example, for a situation where you don't know the initial state. So you're in a situation where you don't know the specifics of the case, and are asking, well, what are the possible reasons why this claim could be true or not? Or you're giving a partial state and say, well, I know that the following things are true, and I know and what things need to be true in the world in order for this claim to exist or not to exist. So what do I have to ensure that is true or not true for the claim to exist or not exist? And there are actually developed techniques for that. So you can use things that were developed for planning in order to answer essentially. Oh, okay. Interesting. I didn't know that worked. Thanks for the pointer. Yeah, it's the point is that it's not. Well, the point that I wanted to make is that there are essentially developed techniques for that, which you can just use in planning.
Yeah, Gregor, are you looking at this chat? Maybe it's better for everyone to open the microphone and make the question. So Giovanni,
no, I was following up on what Trevor put in the chat. So I also was wondering why you just modeled your knowledge as rules, where you have that the contract is the supplementary performance is due given a set of conditions that can be conjunctive, alternative, or whatever. And then you can use abduction or other tools to provide conditional answers in order to cope with the problem that you were mentioning. So what is the benefit of relying on planning? But I think that looking into opinions is really an important idea, and there is a lot of knowledge to be get from there. So your project makes a lot of sense to me. But
yeah, so the question is, what do we actually get? Well, my intuition was that we actually get like a lot of tool support in the way that Chris Benzmüller argued for using Hall. We get a lot of tool support from existing systems, from existing planners. that solve specific problems in this case. Like, what should the initial state be in order for something to be true? Yeah, I guess the answer isn't really satisfactory to that point. The main point of that work was actually just to see that it's possible to model it this way, and to see what we can do with it was a later, or is a point of further discussions essentially that I.
Okay, thanks. I think it will be interesting to see what kind of procedural information you need to put into planning, and what kind of information instead could also be put into more standard backward chaining approach.
Pierre Carbonell has a question also.
Yes, that was to Inga. Maybe she can show slide 4 again, if I remember well the number.
Yeah, sure. Second. So slide 4, you mean this one, or?
This one, yeah, yes. So you have inculpatory and exculpatory evidences, but I'm not sure I understand the result to the range of 0.7 to 0.8. How do you get that?
Okay, that's a result of the constraints we defined before. So before we defined the constraint of coherence and support coherence. So if you maybe look on the right at this graph, then you can see that we have if we implement these constraints and we have the prior belief statements, then we know that according to coherence, or upper bound for the argument of innocence is given by the belief in the attacking argument. So in this case, 1 minus the belief in the attacking argument, which is 0.8. And this is the upper bound. And support coherence states that our belief in the supported argument is given by the supporting argument, which provides a lower bound of 0.7. And these are the bounds that are given here.
All right, I get it now. Thank you. Yeah.
Okay.
So any other questions?
So maybe a follow-up question to the questions about planning. So I found the idea quite interesting, but maybe it's a stupid question, I'm not sure. So I was wondering, I mean, if you have a planning problem, usually you have a goal and operations. Maybe it's obvious, but for me it wasn't quite obvious what the goal here actually is.
The goal is the root task. So you're given one task that you have to execute. And you have
so you say you want to show that
that a specific claim is true, and then you're essentially applying this. It's kind of a grammar structure in the end. It's kind of a context-free grammar. You're applying these grammar rules and get in the end a word that you have to check for executability in order to see whether the claim actually holds or not.
Okay, I see.
And the possible words are essentially if you derive all the possible executable plans, then you get all possible reasons why the claim can be true, for example.
Yeah. So what planning system do you currently apply?
We are using our own, it's called Panda.
So computationally, how does it relate to backward chaining? So I guess it's a fair question.
It's a lot more difficult. So the formalism that we're using is X-time complete.
Okay, yeah. Okay, but in the worst case, I guess, right?
In the worst case, yeah. In practice,
it's far easier.
Is
so simple.
Yeah.
All right,
Maybe
thank you.
Just a comment on that from my side, if there's nobody else asking a question. I find that quite interesting. I mean, I've been working for a long time on the combination of planning and tune proving, with the aim to actually get a hand of this very bushy and involved search space, in particular when you work with general tools like we do in higher order logic. And the claim here was that when you are in certain domains, that you can very well capture this domain specific knowledge in terms of planning rules. And then you could have an abstract level that was at the time what we were investigating, plan for a justification for a proof in context of mathematics, and then see whether this can be refined with the other tools. So I haven't been working for that in a long time, but I think here with the legal domain, we have an interesting domain where you might have very well informed kind of patterns that you could well capture eventually with plans. And you could eventually combine even the two approaches in direction of using tools that Gregor presented and what I presented, in the sense that the planning could eventually help to structure the search for arguments.
True, that was actually something that I noticed while thinking about this, that planning is pretty much only useful for structuring the opinion and not for doing the, let's say, actual logical inference and argumentation at the bottom layer, because it's just not suited for that at all. But it's
so our argument a few years ago, but actually that didn't take off against the quick improvements still in terms of first order reasoning, for instance, at the time, was that the combination of the two techniques, planning from AI and proof search, gets you further in certain domains. And I still believe in that, even though in the meantime, so the last decade has proof planning kind of more or less disappeared from the scene, but I don't think that this is it was probably due to other reasons than to the conceptual idea here.
Okay, so Trevor has a reference here, suggestion for bibliography for Gregor also.
Yeah, thank you very much.
So any other questions regarding this second session? So maybe we could come back to the first session, and I believe that Giovanni had further comments that
no, I have to remember. Sorry. No, but is Nino still there? No, is Nino here with us, or is he going?
Here.
Hi, Nino. No, I was wondering one thing about your presentation. So in your language, you already have priorities, and you can express priorities between canons. So I wondered, why do you need to rely on your special operators for alternatives when you already have priorities between canons that can be expressed as rule priorities in your system? Is it something that is needed, or is just?
Well, technically, there are ways in which you can at least in the logic, you can translate the theory in an equivalent theory without the operator. So technically speaking, in the specific application of the operator, this is just syntactic sugar, right? In general, the operator does much more than, and there are, of course, some papers where the operator was applied, for example, in preference logic or in contrary to duty. But in the context, is just a way for keeping separate two different things. One is when you have an alternative between different types of canons which are compatible from a logical point of view. And while the superiority relation is used to solve conflicts, right? Because from a legal point of view, you have two different problems, right? One is when you have a ranking among canons, because one type of canon is preferred, right? But you can have, for example, the two canons leads to the same outcome, right? So from the outcome perspective, they are not in conflict, but still require the first type of canon rather than the second type of canon, right? So we did it essentially for keep separate the two problems. But from a technical point of view, you're right, in this specific application.
Okay. And did you also, did you also consider the possibility that two canons may join forces, that you may have a kind of accrual when reasoning with canons?
Yes, you have. In fact, as you see in the proof theory, when I've shown that you can have restatement, in fact, you have reinstate is a type of accrual of canons. So you can use different canons for supporting the same outcome. Yes, absolutely. We didn't explore fully, but absolutely, this is one thing that can be done.
Okay. May I have also add something also Christoph presentation, Giuliano? Or am I?
Yes, of course.
No, Christoph. No, my reference to preferences was because I've seen that you cite your references to preferences is to ceteris paribus preference, isn't it? That paper by what the authors of the paper I think is the
Van Bantham.
Yes, yes.
It's Van Bantham.
So I have something that I have tried to do is also to make a ceteris paribus deontic logic. So I think that it would be interesting to see whether ceteris paribus preferences as applied to values can also be connected to a ceteris paribus preferences as grounding the semantics for a deontic logic. So maybe the two things, it would be interesting to see how the two things get together.
Mm-hmm. Yeah, I'm very curious, and I think especially in this area with preference logics, the idea of interaction with the system and experimentation and assessing these kind of modelings then against some eventual benchmarks that have been set up really makes sense, because we really still have ongoing debates about what the right approaches are there, and they will eventually last for a long time. So I think it's an area where we have to work empirically and to make it possible that you can easily exchange things in frameworks. And I have to say, I'm not an expert yet in preference logics, and neither so is David. We quickly jumped on that, and we picked the paper by Van Bantham, found it plausible to use in the context, and there's no claim here at a meta level that that's the best choice for the problem we are tackling. In fact, I have now a master thesis student, or a potential one, I still have to convince him that this is an excellent topic, who wants exactly to look at this layer in our modeling. So what kind of preference logic is well suited for the purpose here in the long run from different perspectives? And you might have different criterions you are after, like one is for sure efficiency for me in practical terms, but then again, does it cover what you want to cover? So does it do ceteris paribus in the sense you are after? And I think that's an excellent flaw for such work. And maybe we could join forces right away and pass your question, for instance, to such a student to work that out.
Great, that would be great.
Yeah.
Okay, Pierre Carbonell has one further question for Inga.
Yes, thank you. Yeah, in the title, there's a mention of probabilistic epistemic argumentation. And I was wondering why the use of probabilistic, because what you refer to probability looks to me more like the strength of an argument. I don't see really a stochastic process or a random process in there. Any comment on that?
Oh, I can take that question, Audrey. So it is based on probability functions in the Kolmogorov sense. So it doesn't look like this because we only look at marginal probabilities, and this is the reason why you only see probabilities for single arguments, but the foundations are really standard probability functions. So it's not obvious if you look at the examples because they are simple, but it's just standard probability theory that we apply here.
Okay, and so where is the randomness then?
Where's the randomness? I mean, there is nothing like randomness. It's more like your, I mean, if you look at the Bayesian network, for example, you can also interpret the outcomes of the marginal probabilities in different ways. And usually the interpretation that you have in AI is that they are subjective beliefs. So it's really something like a static framework and not a dynamic framework where you really reason about the probability of events to happen. It's more like your belief that in the case of argumentation, you believe that something is accepted or rejected. So if you want an intuitive interpretation of the probabilities here, the meaning is just as it goes closer to 1, your belief in acceptance becomes closer. And if the probability goes to 0, it means that your belief in rejection becomes stronger.
So it's the strength, the probability that you use is representing the strength of the argument, right?
Yeah, yeah, the subjective strength, you could probably say. I mean, terminology is always a little bit difficult. I guess you could say something like that. So if you're familiar with this idea of degrees of belief that is often used for the interpretation of probabilities, then it's basically that just instead of considering something like a logical formula, we have arguments here.
All right, okay, thank you.
Okay, there is a discussion, an interesting discussion going on in the chat between Antonino Rotolo and Trevor. So I'll read them out here, so then we can continue on that, because it connects with an initial discussion that we had in the last session about the distinction between linguistic interpretation and legal construction. So when are we talking about argumentation on meaning ascription, or are we talking about changing the law? So Trevor started the discussion saying that are we before literal interpretation when law follows current meaning? And then Antonino said, good point, Trevor, usually it's the current ordinary meaning. Then Trevor replied, but when the law was written, man included woman. It is only since that perverse interpretation has become possible. Lots of people say that we should use the language of the founding fathers. Antonino replied, yes, true, but interpretation is performed now, and one could say that man now mean adult male, and then to state if you argue that the original intent was human being. But you are right, it's just a matter of establishing the temporal reference. Okay.
No, I didn't argue that this is the right way to interpret the literal meaning. I was simply, but in any case, depending on the temporal reference, you may distinguish literal meaning. Yeah, there are theories. This is a matter of philosophy of language, right? John Searle wrote a nice paper on the literal meaning, right? By the way, he argued that literal meaning doesn't exist, right? It's an invention of jurists. But you know, literal meaning in the context John Searle theory is the meaning of the context of use of the language. So if you apply now the law, you interpret literal meaning using the standard of the language where you apply. But you know, I don't claim that the male or female is uomo is the literal meaning means that or that. I simply assume that you can distinguish the literal meaning from other type of meaning ascriptions. For example, you could argue that in fact the interpretation of uomo as human being is the literal meaning, right? Because at that time that was the literal meaning. Fair enough. But you can have another type of literal meaning if your temporal reference is now. So conceptually, you can have this distinction in any case. So, but Trevor is right. I mean, if Trevor is right in saying that that the literal meaning could be not a male, adult male, but human being. I don't disagree with that. It's enough to have to keep the distinction between literal and intent. You know, I don't insist on this, just to explain argue that the literal meaning could be this, because my temporal reference was now. If you consider now, then the literal meaning is this, right?
Yeah, and I believe that literal meaning must refer to what language community are we talking about.
Exactly.
So is the language community of jurists, is the language community of commons and ordinary people, and actually the original community exists at a given point of time also. So there is another, I think that no jurist would say that man should be interpreted as male. I have another example. For instance, in Brazilian law, there is one of the rules says that it's forbidden to abort. And the other, right after rule says that it's permitted to abort in case of rape, sexual abuse. So no jurist would say that these rules are conflicting. They say that it's forbidden to abort when there is no sexual abuse, and when there is sexual abuse, then it's permitted to abort. So, but this is already a process of change. Actually, we could say that if you we could talk about settled meaning. There are meanings which are settled, even though they depart from ordinary meaning of the legal texts. And this may be a point to distinguish when are we dealing with construction, when we depart from settled meaning, or when we are dealing with a literal meaning. But okay, there are many others that want to jump in and talk. So please, if everybody who is talking in the chat could express opinions here, it would be nice because it's being recorded.
I have another comment on that if you have time. So as a person who knows a bit about modal logic and intentional logic, does the problem disappear when we just say that our world knowledge is in general intentional, always dependent on the world we look at? And some of the notions we are dealing with might have a fixed or extensional meaning that jumps from one word to the other and stays fixed, and the others are highly dependent on this context, the word context. And I think in such a setting, we should be able to model some of the issues we have just talked about. And my question is, what else, what could you consider in such a setting as still an open problem that would fall short in addressing the issues of context-dependent interpretation? Or is there something that I would have to pay attention to in addition? Because that was immediately triggering me now to use intentional logics eventually as a basis for modeling world knowledge.
Yeah, I agree. But the context is what counts. I mean, you're right. I mean, if you say the literal meaning doesn't depend on context, you're endorsing a theory of language which is absolutely not. Not reasonable, right? Nobody now in philosophy of language argues that the language means something in a universal perspective, right? At least this is not my view. My view is that literal meaning depends on the context. And then I think you are right, but also Trevor was right pointing out that depending on the context, this literal meaning could be exactly what I mean as the regional meaning. But independently of that, you must distinguish the two things, right? The fact that depending on the context, something can be literal, something cannot be literal. And I agree. Yes. I think it's interesting because we could introduce, for example, temporal reference in having and then you can argue that the literal meaning at time t is equal to the coherence, the meaning by coherence at time t plus 1. This is exactly what we say, right?
Well, let me introduce another subject. Nico Potica is also discussing another point, but it's about Let us keep a little.
Yeah, I don't think that it's generally interesting. It was just for here.
Yeah, it's on the other. So let us keep further in this discussion of interpretation. And I have mentioned Bobbio's text on trying to describe the rational legislator, which is actually a figure that represents legal interpretation by introducing some rationality in the will of law-giving activity. So what he makes an interesting distinction, which is there are some canons of traditional legal interpretation which are mandatory. That means interpretations that violate these canons are simply unacceptable, while there are some canons which are a matter of preference. So the canons which are mandatory, according to Bobbio, are coherence. So an interpretation that delivers as outcome a conflicting obligation is not to be accepted. And another canon, which is interesting, which is something that has to do with, he calls justice, but the idea is that the rule cannot be arbitrary. That means that interpretation cannot deliver it as outcome some obligation that has no purpose at all, or prohibition that has no purpose at all. So it cannot be a system of rules which are arbitrary, so they do not pursue any relevant value. And the other ones, which are a matter of preference and a matter of balancing, which might be defeasible under some system of preference, are the interpretations that deliver outcomes which has gaps, or which are imprecise by the same text, the same word in the text receives different attributions of meaning in different parts of the interpretation. So, so this is also an interesting thing. Maybe what he calls mandatory is something that could be incorporated in the structure of the logic where the discussion goes on. But this is just something I would like to add to check how could we model something like this. Maybe the mandatory are rules which are in the logic. In Nino's proposal, there are two outcomes of a coherence interpretation which conflict, and then both are dropped in giving room to substantive reasons.
Yeah, I mean, you may assume that the legislation is rational, right? For example, if it's rational, it's not redundant, okay? Which means that it doesn't make sense. Suppose that you have two provisions, and then you interpret the provision using different canons, and the canons point to the same result. Then it's not good from a rational point of view, because it means that the legislator was redundant, because he drew two provisions meaning exactly the same thing, right? So rationality can be implemented in different ways. Absolutely right, but yeah, I think and this is something that is nice to investigate. So it would be nice to take my framework and identify different types of rationality, and then exploring which type of ranking among canons, or how a model different types of rationality, using modeling how they interact in the logic. Trevor's was mentioning but I saw some replies too, some replies that they mentioned is that the intention is the literal meaning of that time. Not necessarily, could be, but not necessarily, because it depends at that time, right? Because the original intent of the lawmaker could be that at that time, the lawmaker could deviate from the literal meaning, at the ordinary meaning of that time, right? So it could, for example, at that time, the lawmaker could mean something not ordinary, right? So the funny thing is that something at that time which was not ordinary could be ordinary now, right? Is it just the fact that the language, ordinary language, is not stable, can change in time, but that there are plenty of examples where you see this, right? So I think what I learned from what you said is that it would be nice to introduce temporal reference here. That's something I definitely like as an idea. Temporal context, the context of use is definitely a very interesting thing.
Yes, there is a discussion also going on here between Florian and Gregor. If I don't know if Florian and Gregor would like to.
Would be nice to see to listen to them directly, the discussion, right? And then I can try to interpolate with them.
True.
Yeah, I was talking about the US founding fathers, the slavers.
Exactly.
People say that because the founding fathers didn't think cutting ears off was good,
true,
then full and unusual just not prohibited today.
Yeah.
But
yeah, I agree.
But 5 years ago, the sounded silly.
Yeah.
But with Trump, they're back to basics.
Yeah. But I think you refer to the founding father in the United States. That's quite a very interesting case. But why they use this? Because they have the originalism. For Americans, the Constitution is like a Bible. Is a big single Bible. So sticking to at the end of the day, behind the different types of canon, there is also a value, a axiological view of the legal system, right? If you stick to originalism, but originalism doesn't mean necessarily literal meaning, right? Because the founding father could mean something in a way which was at that time different from the literal meaning, right? So conceptually, I would say that originalism, so the original intent, doesn't collapse into literal meaning. Could, but doesn't collapse by conceptually, right?
Yeah, we have the same arguments about the Bible.
Exactly. It's not by itself that I was mentioning the Bible, because for Antonin Scalia, right, the judge in the constitutional in the Supreme Court in the U.S., who was one of the supporters of originalism in the recent times, he was precisely using the metaphor of Bible, right, to say, look, the Constitution is our holy book, and then we have the duty to go to the original intent, the founding.
Yeah, but that was, Americans are fundamentalists.
Exactly.
Liberal theologians like myself interpret it how they like.
Yeah.
Both the Bible and the Constitution.
Yeah.
Okay. Does anyone have another point about this discussion on interpretation?
No, maybe, sorry, Giovanni, am I muted? Just a second.
We can listen, Giovanni. We don't see you, but we can listen.
Yeah, no, I was just I think that an interesting point. I think that an interesting point that is raised sometimes is that whether you have to distinguish not so much between literal, but between semantics and pragmatics in interpretation, where through semantics you figure out the meaning of an expression using just the linguistic knowledge, and then when you bring into context, you expand the meaning or you deviate from it, taking into account also the pragmatics. And then I think that a further issue is when you move away so much from the semantics that you get something that is incompatible with the semantic rules. And in that case, you override what is in the language of legislator. So I think that maybe we should try to fit the idea of change versus interpretation in the, into an idea that concerns instead the connection between the semantics and the pragmatics of language. A further distinction, but that is very complicated. I don't have clear ideas on that. A further distinction is when taking into account the purposes of legislation, of the values of the law, you go beyond what may be reconstructed as the intention of the authority who enacted the law. And then in this case, it will be a change. Another perspective would be to look at the diachronically. So you have a change when you have an interpretation which is accepted, and then a new interpretation comes up that overrides the one which was accepted before. So you still have a document and you have alternative interpretation, and the change takes place when there is a temporal sequence. But so I think that just some ideas, but the problem I think is very difficult, we need to find a way to conceptualize it adequately.
Yeah, I mean, in my model, I was the approach was very modest. So I started with the canons as they are codified in the doctrine, right? So I basically worked on the list of canons of Summers and McCormick, right? Or there are other lists. I mean, we work together. You work with Doug and Fabrizio Maccagni on that, right? Too. So I mean, you take a list and then you identify the canons. If we want to disentangle and we want to those canons and try to reconstruct them in a deeper perspective, then you need context or pragmatics, time, and stuff like that. So yeah, in my approach, the thing were simple in a sense, but I understand that you can elaborate on this in a more refined way. I mean, I got a lot of suggestions for a couple of new papers today.
Okay.
Yeah, just one point which I think it's also interesting to explore is that these canons are also related to what the so-called methodologies of interpretation. So each canon may be related to one sort of methodology as developed by the German dogmatics of the 19th century, which means, so if you are looking for intention, there are the historical method of interpretation. About coherence, there is the so-called systematic method of interpretation. And so looking into this methodology is interesting, also relating to canons.
Yeah. Yeah, I mean, you know, I also, Giovanni was mentioning this, right? Saying that you distinguish the original intent from the rational intent, right? So yeah. Rational intent is basically teleological reasoning. So you don't pay attention to what the legislator did or thought. And if you have the historical intent, then you have to go back and to go back to the past and understand what they mean, what they meant at that time. There are different approaches. I agree, and they should be identified. But you know, sometimes you know they are tricky because you use the same word, intent, and then but in fact there are two complete different ways of reasoning. You know. Yeah,
and you have different terminologies also. There are the so-called sociological method, which tries to understand what are the consequences at a given time, in the time of application of the of a given interpretation as well, and it has to do also with the meaning that may be attributed to the text at that particular time of application. So,
but you know, the interesting cases where you have, for example, some terms in the law which can have a technical meaning and an ordinary meaning, and you don't know whether the lawmaker was resorting to the ordinary meaning or to the technical meaning, and then you have to decide, because sometimes the lawmaker is not so clear. And of course, if you have the technical meaning, you have some definition somewhere in the legal system, that you solve the problem, and then which means that you go to the sort of a systematic approach to the law, right? But I think these are the most interesting cases, right? There are plenty of examples from the law. But you know, I agree. I mean, behind these, there are some views regarding the law, different views regarding the law in terms of how the law is, and there are different views regarding how the law should be. So, what type of values that you want to pursue, what priority, axiological priorities you have in your reconstruction of the law. So, it's a very complicated matter. This is the reason why I was very modest in the paper. So I tried to work on the canons as a list first, and second, I wanted to. I wanted to start with some theoretical assumptions rather than philosophy, like Althros. You know, I didn't want, because otherwise you have to elaborate your own theory of law, which is very complicated.
Mm-hmm. Yeah. Okay, so what time is it now? So yeah, this is already, we are over the time, so this ends our second section. We have now a lunch break, and we get back at 3:50. Is that right? Yeah, 3:50 in the afternoon. So. Thank you very much for the presentations of this section and for the discussion, which was quite interesting. Trevor sent a message here that we cannot attend the afternoon section. So thank you very much again, and see you then at 3:50. Okay?
3:50. Okay.
Okay.
See you later.
Bye. So hi everybody again. Let us then move forward. Now it's Florian Liedelberger who is going to deliver his talk about merging traditional contracts and smart electronic contracts.
Sorry, can I just take like 30 seconds to go to the bathroom? Or?
Yes, of course. And actually, since we have enough time, and we have just 2 presentations now in this session, I believe that we could use a bit more than 10 minutes. I think that 15 minutes for each presentation would be better. And even then we would have more or less 30 minutes for discussion. I think it's more than enough. Nino, I think that it would be a good idea if we could later discuss this distinction between linguistic ascription of meaning and legal construction to see if we can get some ideas to develop on that. Well, just a comment, Florian. You would have 15 minutes to deliver your talk because we have enough time for discussion then later.
Okay. Yeah, now I roughly budgeted like 1 minute per slide, but I'll see how it goes.
Okay.
Yeah? Can you see my screen?
Not yet.
Oh, no, maybe.
Now we can.
Cool. Okay, so yeah, basically I was looking at different formalisms or methods to merge like more traditional legal contract and well, most systems actually use smart contracts, but I think it could also refer to general e-contracts, like if you have some other system that uses not smart contracts in the blockchain space, but some other system where you can make transactions or otherwise affect legal or financial relations. And yeah. And so, yeah, exactly how these e-contracts and legal prose can be brought closer together. And for example, there, with Ricardian contracts, there is like a very popular idea, for example, which I didn't have time to discuss in the paper, but which basically just connects legal prose and functionality through some hash value, for example. But that's also still very technical, especially if you look at the specific the spec for that. So ideally, I think, especially for lawyers, the idea would be that you have something that still kind of looks like a normal contract or like a natural language or legal language, but still has some functionality also. Yeah, and so I looked at various things also that were there before. And for example, you have various kinds of legal markup systems, such as Legal XML, Akuman, Tozo, or Legal Knowledge Interchange Framework, I think, LKIF. And yeah, then you have various other kinds of e-contract systems or categorizations, like Common Accord, for example, or Core Project, and also some commercial offerings. And yeah, you have metadata systems, for example, SPDX for licensing, which, for example, Certain in his paper on computable contracts also referred to. Yeah, the idea is basically that the license is signified by some identifier, and then you can say, okay, this journal is, in his example, it's a journal. This journal is licensed for not the whole university, but some specific students who need it. And then based on that, you get like different license terms. Yeah. And yeah, with e-contract systems, you might also have differences between, for example, document management, contract or lifecycle management, and then the more advanced, or let's say academic, also to some degree, debate, and also what I will be talking about are most, can maybe best be described as DSLs, like domain-specific languages. This also refers, for example, to the Stanford initiative, on computable contracts, though I think they haven't published that much yet. So I'm looking forward also to what will come of that. Then here I have also a slide overview, which I had to cut from the paper, unfortunately, but I think it gives a good overview. So on the right upper hand, you have like the smart contracts and their languages, which is like Solidity, Viper. Yule is like more like a lower level language. Lexon, because it can compile or transpile to Solidity. Then SCTs are what are from a paper by Meng Wong, which the founder of Legalese, who basically categorized different systems into generations of e-contracting or contracting software. And yeah, Legalese is one of these, contract form, common accord, which are both yeah, somewhere in between like a specific language and a templating system, and also have various kinds of aspects of recurring contracts. Then with NLP, I basically signified everything that to some degree has like a more natural language aspect, which is Lexon. CDL is like the Stanford initiative. Logical contracts, natural language is by Kowalski, who presented at RuleML 2 years ago or so I think. And then on the right lower hand, you have like the more logic-based approaches like defeasible logic plus some interface, Prolog, or also logical contracts in the sense that it's also based on Prolog and can also be used without the natural language part, I think. Yeah, and then obviously, because I'm also looking at it from a legal point of view, and always in these contexts, the thing comes up, okay, what is actually the legal part, or is even some code that we have or that we connect to a contract, is that actually a contract, or what do we need so that it is a contract? And for that, I think, or for example, some lawyers wrote papers about, well, it's just some script. So, you know, it's not actually any kind of contract. And I think it's not that easy, because actually in most cases, contracts don't really need like a specific form. You just have to have the agreement. And I've found very interesting or useful there this image of the contract stack by Alan that he presented in a paper. And so I made this overview here where on the left-hand side, you can even apply it for legislative stuff, I think, where you have the public communication, the preparatory documents, the legislation. And for normal contracts, you have the intent, you have the communications, you have the contract text, and that all gets to some degree interpreted together. And then for an electronic contract, you have also the intent, the contract text. By contract text, I mean like prose text and not code. And then you have the executable code, and all that together gets interpreted partially by a machine, but also if it would ever get to court, also it would be interpreted together, I think. And that's also what Alan said, and that's a very good comprehensive view, I think. So for my paper, basically in the past already we did I helped with the paper on comparing Solidity as an imperative programming language to defeasible logic. And for this paper now, I tried to make a more realistic example license, but still keeping it relatively short. And then I compare basically the natural language version, the Solidity version, which is like the main programming language for Ethereum, a Prolog version, and the Lexon version, which is like a newer, yeah, more natural language-like language to write in this case, smart contracts, because it compiles to Ethereum code as well. And to make the license better, I included like a license grant, a header, and the licensing and the breach fee, for example, and also try to apply criteria by certain in his computable contracts paper, for example. And my main criteria are, does it capture the meaning and spirit of the contract? How are the syntax and the semantics? Is it functional? And does it look like a contract? Of course, look like a contract is a little bit vague, but I think it's important because I think at least for lawyers or people who normally do contracts, this is quite important. And that's actually also what they refer to when some of them say, well, obviously code is not a contract. So this is, here in the presentation, I'm just giving excerpts. So this is, one of the examples, the first article of the example license, where basically the licensee comes a license to evaluate and grants this, does this in exchange for a licensing fee. And yeah, obviously this example is a little bit difficult for a computable contract because not everything can be properly automated. So that's why I added the possibility for an arbiter. And yeah, and it could also be integrated with the example by certain, with the metadata for SPDX metadata for licenses. Then this is an example of the excerpt of the Solidity contract. And right away, we see that it's much more verbose on one hand, but also much harder to read because it's much more explicit. And yeah, so it's not very readable. It has a lot of functionality, but it could definitely need a stronger link between, well, if there's a prose contract as well, it would need a stronger link between the prose and the code, which can be also done by external means, but it's not necessarily the case. Then with Prolog, yeah, I mainly chose this because I think it's easier to replicate and use than, for example, defeasible logic. The main things I used are facts and predicates and rules. And yeah, one issue, of course, is that when a normal programming language, at least like in Solidity or in law, you always have some kind of grounding system, like you rely on laws that contract law is based on, or you rely on the programming language's default library. So some facts are already defined. For example, in Solidity or also then in Lexon, a person is, or like either a machine or a person is defined by an address. But in Prolog, for example, I first have to decide, okay, how do I define a person? How do I define licensee? Things like that. And so a lot, it also depends on how I define my facts. And this can get quite confusing, especially when I then have to actually want to do something with that. So it captures most of the meaning of the spirit. It's not that accessible though, and yeah, still does not really look like a contract. Then this is the Lexon example, and it's still very structured, and in that sense, a little bit like Attempto, for example, which I didn't look at in this paper, but another one. Yeah, and so, for example, variables are defined by square brackets, by quotation marks, but otherwise it's quite normal looking. And this is also just the excerpt from the first part. Then I made a nice overview table. I think we don't have time to go through all of it, but at least a little bit. Where I compared them, for example, also according to the binding, and this is from a paper by Hapio, where they discuss this as one of the main important parts, and that is exactly what I try to go through. The binding is basically the interconnection between the legal prose and the code. And then yeah, defined whether they're executable, how concise they are, if they're grounded, and grounding is actually very important, I think, and that's what, by that I mean, if I have to define my facts on my own or if they are based on something. So, well, one problem is that it's always limited by the target environment, such as the Ethereum virtual machine. And then, for example, in the case of Lexon, it's very advanced and it looks very much like a contract, but it's not AI, but it also doesn't have to be. It's still a little bit difficult to write because it has a limited vocabulary, and there's no Deontic logic, for example, and that could definitely be a problem, but that also depends on the base environment it's based on. Okay, thank you.
Thank you, Florian. I will now move for the next presentation.
Should I stop? Or?
And Stefan Gostoyek, knowledge-based legal document assembly. We also have 15 minutes, okay?
Okay. Hello, everyone. My name is Marko Markovic, and I would like to present the research on knowledge-based legal document assembly conducted by me and my colleague Stefan Gostovic. First, I would like to say a few words about issues in legal document assembly. To assemble a legal document, some person has to have certain knowledge of regulations and legal theory. This knowledge is usually gained through legal education. Besides legal theory and regulations, to apply this knowledge to a particular case, a person has to be experienced in assembly of legal documents. These requirements become an issue when non-lawyers are assembling a legal document. They usually need to hire a lawyer to create necessary documents for them. On the other hand, to optimize the creation of legal documents, educated lawyer usually search for an existing legal document, most similar to the subject of the document they need to assemble, and then they use existing document as a template, adapting it to the particular case. Such a procedure may lead to errors if some of old data mistakenly remain in the new document. We have recognized two parts of knowledge relevant for legal document assembly. The first part is knowledge gained through education in law schools. It can be found in regulations and legal textbooks. Usually these sources don't prescribe exactly how we should write some legal document. The second part of the assembly knowledge is the experience or so-called tacit knowledge. It is a skill of legal professionals to apply formal knowledge on a particular case and to put all the parts of the legal document in the right place. To use the assembly knowledge by computer, we need its machine-readable representation. We have represented regulations by legal rules. Among available formats for legal rules, we have chosen a very powerful legal rule ML format. Then we have represented tacit knowledge using document templates. As a format for document templates, we have chosen ToxGene because its syntax is based on well-known XML schema language. We propose a legal document assembly method that uses machine-readable knowledge. As I said before, we have chosen legal rule ML and ToxGene standards for its representation. To apply this knowledge to a particular case, we need to collect the case facts. We perform this action using the question-answering approach. Using the knowledge base and case facts, the feasible reasoner is able to conclude other document data that can be inferred. For the feasible reasoning, we have chosen DR device. Having semantic of all data relevant to the document, we generate machine-readable legal documents. We have chosen the Acoma and TOSA format. This format is also adopted by the OASIS Technical Committee as the basis for legal document ML format. Besides the generated document, we decided to offer argumentation for reasoning results to support claims included in the document. Our legal document assembly method consists of two phases: the analysis phase and the synthesis phase. The aim of the analysis phase is the preparation of the knowledge base and configuration of the document assembly process. The assembly configuration simply defines a set of case facts necessary for the document assembly and questions that the user should be asked in order to enter the required data. The synthesis phase uses assembly configuration to perform collecting of case facts. After every input fact, reasoner draws conclusions important for the document. For example, is a person minor or adult on the basis of age? Or which offense is committed on the basis of driving speed, victim injuries, type of illegal substances, etc. These relations between input data and reasoning conclusions are useful to argument claims embedded in the document. Finally, the synthesis phase generates the document and constructs argument graph based on the reasoning results. The flow of the synthesis phase is organized as shown in this diagram. On the basis of assembly configuration, input data are collected in every step. Every step, user is asked to answer a simple question. After he enters the required data, the reasoning is performed. Then the document is generated and the argument graph is constructed. These tasks are repeated until all case facts are collected. Because the assembly process is performed in cycles, the document is built successively, making it easier for the user to track the influence of each fact on the generated document. As a proof of concept, we have developed a legal document assembly system. This screenshot presents its user interface during the assembly of an indictment against a person for causing a traffic accident. The user interface consists of 5 parts denoted with letters A to E. Part A presents the type of document chosen in this assembly process. Assembly progress is illustrated using buttons. For every assembly step, a button enables the user to jump on some of the previous steps and revise his answer. Part B presents a dialog box for entering data. It displays the question and lets the user enter his answer. Part C contains the generated document. The document is generated successively in steps after every given answer. Part D shows the argument graph created during the reasoning process. All conclusions inferred by the reasoner are graphically presented, showing which fact and rule give which conclusion. Part E gives the user some explanations for data he is asked to enter. For instance, it could be excerpts from legal textbooks or some articles of the relevant law. Let me conclude the results of this research. First of all, this approach has significantly improved legal document drafting. This is also confirmed by evaluation when 24 law students were asked to test our assembly system. They gave score 5 out of 5 for easiness of use and score 4.88 out of 5 for simplification of the assembly process. Another benefit of this approach is the assembly of machine-readable legal documents. Preserving semantic of the data embedded in the document facilitates its further processing and contributes to the interoperability of legal information systems. Our system provides the user with an argument graph. Our intention was to avoid black box scenario in the reasoning process and to transparently present influence of regulations on the assembly process. This graph can help the user to better understand the relations between claims in the document. The system also provides the user with explanatory material, helping him to understand why some fact the user is asked to enter is important for document assembly. This is beneficial for both law students and non-lawyers. These features give a potential for introducing our system in lawyers' education. On the other hand, preparation of the knowledge base is not supported by our assembly system, since both parts of our knowledge base are XML-based documents. Any of XML editors are applicable. In future, we would like to improve our system with a domain-specific language to facilitate this task. Text produced by the assembly system is constructed by joining text fragments, or so-called string concatenation, which can lead to grammatical errors. A solution for this deficiency could be an application of natural language processing techniques. Thank you for your attention and feel free to contact us or to check out our GitHub repository.
Thank you very much, Marco. I now open for the audience to make questions.
Maybe I can make a question to Florian. Giuliano, can you hear me? Let me put the start.
Yes.
Okay. So Florian, you presented different languages, but is there any difference in the normative content that is conveyed by your representation in the same of the same contract in these different languages, or it is no difference as you can judge?
You mean like in the, let's say, the
prologue versus solidity or versus?
Yeah, I think it's. I think the main idea is that I'm not sure if I said that before, that in Lexon, for example, because the structure that is translated from the sentence parts to the executable code, like a lot of the syntax and the structure is kept intact, in fact, so that also the resulting solidity code looks more like, well, it's closer related semantically or structurally to the Lexon code that it is generated from. So also on that level, you have a closer link between them. Whereas, of course, that's maybe also possible with like Solidity or Prolog, but it's much harder. And it also, at least in Prolog, it would depend on how you define your facts and predicates a lot. Because I had also an example in, I'm not sure if I kept it in the paper because I was trying to make it a bit shorter, but like for example in Prolog you can just define facts as like nouns, but you can also define, for example, a noun in combination with the verb as one fact or a relation between two facts, and then that could change like potentially the whole meaning, right?
No, I was thinking, for instance, I don't know that Nino and Guido, for instance, Nino Rotolo and Guido Governatori, they have represented in defeasible logic some complex ideas such as deadlines and other deadline, compensation or restoration, all this kind of stuff. So do you think that this contractual content can be captured by all the languages that they've been using, or So I think there are two different issues. One is how expressive a language is, and the second is how easily understandable it is from a lawyer that is used to natural language. Maybe these two issues are separate ones, no?
Mm-hmm. I think in principle, they're all very expressive, but at least from my knowledge, like if, for example, you want to have certain functionality in Prolog, or probably also in defeasible logic, I think, then like you can model it, but if you want it to be executable in some way, you're moving out of the properties that make the language what it is, why you want it to be this way. Like, for example, if you have a logic-based language, then you would need some kind of functional or imperative extension that then performs certain automation tasks, for example. So, and then it depends on this extension, how closely related the model you made and the actually executable part are related.
Okay, thanks.
Does that make sense? Or?
Yeah, yes, I think so.
Okay, so we have 3 questions, 2 of them to Marco and 1 of them to Florian. So I would start just to continue with discussion of Florian paper. I would like Christoph to make his question, please.
Yeah, you mentioned on your last slide that you're not supporting Deontic logic, for instance, now in your approach right now, right? So does that mean that you might suffer from paradoxes or from inconsistencies you might want to avoid, but that they could pop up and they could eventually even trigger, I mean, faulty reasoning, exploitation of inconsistencies, so that you would run in trouble here? And that is the first part of the question. And related to that, is there a way in Prolog in which you could find out that your knowledge base, your facts in the background are kind of inconsistent?
Yeah, okay, first to the first part. Yeah, I mean, that's definitely one of the reasons why that restriction on the Deontic logic is in place. But the second reason is that actually, because it actually currently uses, I mean, that you could have ambiguous problems, or like, especially when you negate like Deontic logic or something like that, then it becomes most difficult, I think. But also because it's currently translates to solidity environment, and in this environment, you cannot really require participants to do something. Like, that's why most of the time it uses may, for example, or goes through an arbiter. So it caters a little bit to that, because, for example, there is so far no direct debit in this normative environment. So if you would, for example, say person X has to pay this, then of course that creates a legal obligation, but it's not as such automatable unless you create like a separate instance like this arbiter, for example, or like a deposit or something. And the second part, yeah, I'm sure it's possible, and probably it would also be better if you know, before you do the license, you create a whole fixed, not fixed, but more comprehensive knowledge base that you then base this license on. But at least for this paper, I didn't have the time to do that. So does that answer your question, or?
Would you like to complement something, Christoph?
No, I'm fine for now. I think that would go too much into details now. Yeah.
Okay. So now I would ask Pierre Carbonell to pose his question for Marco.
Okay, thank you for the presentation, Marco. on one slide you show that there are 23 steps to assemble your document. I was wondering how those steps were determined. Is it predetermined by the configuration that you have, or is it dynamic depending on the user inputs?
Thank you for your question. Steps are created semi-automatically. Our software is able to recognize from the knowledge base a number of facts needed for concluding all data necessary in the document template. And software creates a set of facts, and the user that designs this assembly configuration then makes order to those facts, creating steps by assigning a question to every fact needed the user enter. So in this particular case, yes, it's visible. Let me share screen again. There are 23 steps, and I think in a particular case, this assembly process is not ended. There are more steps needed to complete this indictment.
Okay, and so if in the process some of the questions or step become irrelevant for some reason, is it still shown, or is it removed?
Sorry, I couldn't understand.
Mm-hmm. Well, I would suspect that depending on the answer for step 13, for example, maybe step 17 becomes irrelevant. You see what I mean?
User that design a configuration is able to make order like he wants. There are no preferences related to order of steps by software themselves. User has full control about these steps, and I intended when created some configurations to follow the order how these facts populate in the final document to help user better follow his progress during the completing this assembly document.
Okay, thank you.
Thank you. Now, Alexander would have a question for Mark.
Oh, yes,
right?
yes. Can you hear me?
Yes, yes, I can.
Okay, okay. I have just a very simple question. What can you estimate the time required to build a knowledge base for, say, one type of case, like on the example? Can you estimate it, the time required to build it, the knowledge base?
It very much depends on a number of articles from relevant law that participate in these documents, but I can roughly say that for document template, 1 day could be enough for design, because some of case facts need to be formatted correctly, and for rule base, let's say several days.
Mm-hmm. So it should be pretty quick to establish new template for. Okay.
Yes. Thank you.
Any further questions?
So I have a further question to Marco regarding the templates. Is it language independent, or it's developed for English, for Serbian, or how you cope with the, because you publish the code, right? So I'm thinking about, for instance, applying it to Polish law. So what I would have to do to apply it to Polish, for instance? What would be the necessary steps to adjust the tool?
It is very easy to translate a full document template in another language. For this type of document, first I created Serbian language template, and then just for translation, it was much more simple to create, less time needed to complete the full template design.
So it is somehow language independent?
Yes, of course.
Okay, thank you.
Okay. Christoph, would you like to advance on those?
Let's come back to that discussion eventually. So I mean, what I'm puzzled is about this kind of interaction of a knowledge base with things in product like closed word assumption, and then still the idea of avoiding inconsistencies. So do you see a problem here? Have you experienced some issues in this regard, or doesn't that create any challenge? So that was for Florian. You are muted. You have to, yeah.
So you mean if the, sorry, could you repeat?
You want to model word knowledge and so on. And I mean, if you have a closed word assumption, then everything what you don't state is supposed to be false. And
no, I mean, the idea is that it's, well, it focuses on contracts, right? And most of the time contracts don't state, well, they define some things, but they don't define like the whole world.
Yeah, sure, but you're still, I mean, if it's getting a bit more involved, then you're depending on some modeled knowledge about the word. And I'm just puzzled whether, how I can really trust that such a modeling is not eventually running in some unexpected issues, problems. And
do you mean now the full modeling or which modeling?
I mean, modeling contracts as you proposed, and then just making up factual description of the word, and depending on the assumption that you can never infer anything that you don't want to infer.
Well, I think that maybe goes back to the back to this model of the contractual stack, which always has some ambiguities and or some, let's say, at least vagueness, but that's on, well, I would say on purpose, or because it assumes that contract law at least is designed in such a way that this is not going away anytime soon. So unless you have two parties that kind of decide, okay, we only want facts that are absolutely true or false, nothing else, let's say. Unless you kind of decide that between each other, and even then some default rules might apply in some cases that are not as clear, then you will have inherently some of that. So what the idea is then to focus on translating the parts that are possible to translate to machine automation or reasoning. And then the assumption is that if there is some kind of dispute that cannot be solved by an alternative dispute resolution or the machine, then it would go to court anyway. And then if there's enough incentive for that, and then based on the contractual stack, like the court or whoever would look at all the things anyway, also the default rules based in law. But these are, well, they're not modeled, but that's also not the idea.
I see. By the way, that's the question was raised earlier about generally about my paper as well, our paper as well, the whether they are available to look at. What is the plan? I mean, everybody has that probably as a preprint somewhere, and one can find those. But it would be good to have later on some kind of
or the paper or what?
Yeah, the papers. Yeah, that's more a general question on Roliano and.
I think mine is not yet available, but it will be at some point.
I see. Okay.
Or if people ask me privately, I also can send it privately. Also, if you have more questions, first 2 weeks of October, I'm in Berlin.
Yeah, I think, I mean, I'm kind of tempted to more deeply into it and to see whether you can, whether I could challenge somehow the framework. But that is now, you know, that's when we probably would have to sit down and really look at the details together, and then, yeah.
Yeah, but definitely a good question. Thank you.
Yeah, I was intrigued by the work also by others to model, I think, essentially modal reasoning in Prolog, and I'm still puzzled about the limitations of such an approach. So how suited Prolog really is, and these questions are going in this direction. I mean, if you can do a lot, I see the benefits, but I eventually, you know, I don't have a clear feeling about the dangers that are involved in doing that, and this is something I would like to dive more deeply into. But that's something, sitting together and looking at some concrete formalization and trying to assess the potential limitations. Yeah.
Okay. Any further questions? If there are no questions, just let me make some comments. Not about the papers. I would like first to thank the papers of Florian and Marco for presenting, for excellent talk, presenting their papers in this section. Some of you have asked about the papers and presentations. I believe that we may create a file, a Google Drive, something like that, to put the papers and the presentations. If all of you agree with that, I would ask Marco Almada to organize this and send email to all the authors, so that we can get access. Everybody could get access to all the papers. And another thing that I would like to suggest, I'm discussing with Thomson Reuters the creation of a journal on AI and law, which would be mainly distributed in Latin America. So it has to do with my institute, which is called Logarithm, which is intended also to stimulate the research on AI and law in Latin America, and also call attention mainly of computer scientists in Latin America to develop work in this field. And so one idea could be to have a first volume of this journal. The papers which were presented in this workshop, and there will be more time to work on them. And so this will be one of ideas. And so if you think it's a good idea, this is already an invitation for all of the authors with selected papers to contribute to this first volume. And maybe also others which have others who have joined this workshop may also submit a new paper. For instance, it would be nice to have also a paper by Trevor or by Heka in this first volume. So what do you think?
Yeah, sounds great. I mean, I cannot speak for others, of course.
Okay, so I also, so maybe also we can give you further instructions about it. Of course, I'm still discussing with Thomson Reuters, but they are very excited about this idea because there is no journal on this issue in Latin America. Of course, all the papers would be in English, and the volume would be accessible online, but physical volumes would mainly be distributed in Latin America. So then later I'll give further details on this idea and on this project, and I can let you all inform about how this advances. So since we do not have any further questions, maybe we can make our break now and come back at 5:10 p.m. to our fourth and last section. Right? Okay, see you soon. Hello again. So let us start then our last and fourth section of the workshop. And we have two talks, one by Pierre Carbonell and other by Alexander. So let's start following the schedule. Let's start first with the presentation of the paper by Pierre Carbonell, Bart Bogaerts, Joost Venekens, and Mark Denneker, interactive advisor for tax legislation and observers situations. Please, you may begin. You have 15 to 20 minutes. I think that 10 minutes show to be too tight for the presentation, so you can have your time, and there will be enough room for discussion then later.
Okay, I don't have, I cannot share my screen. Can you give?
Roberto, could you allow him to share his screen?
Of course. So Pierre is already allowed. Maybe I can help him. I'll send him my mail. If he cannot share his screen, I'll be able to help.
It says host disabled participant screen sharing.
Okay, 1 second. Would you try again, Pierre?
Yeah, that's better. Thank you.
Perfect.
Okay. PhD candidate under the supervision of Professor Denneker at the KU Leuven University in Belgium. And the department is about representation and reason. The first one is interactive advisor. Over the years, so practically the user communicates with the system, his observations about his environment. A knowledge base that is specific to the problem at hand.
Pierre,
the system currently yes.
Pierre, a minute. Your connection there may be a problem. For me, it's interrupting every time, and also for others who are manifesting themselves in the chat.
Oh, that's a pity. Maybe. Well, then maybe what I'll do, maybe the other session can start, and I'll come and I'll change my connection, and I'll talk afterwards then.
Okay. So you drop in and make the connection again, right? I can pause the recording and wait for you.
I can. Okay, or otherwise.
Okay, let's start.
So, given that Pierre had faced some troubles with the connection, we are going to move to Alexander. presentation of the Polish question answer in dataset. And then hopefully we come back to Pierre after he fix the connection problem.
So just if in case there are problems with my connection, I have sent the link to the live presentation. So on the chat. So if there is a problem with the connection, you can follow the presentation if you click on the link. Okay. Okay. So let me share the screen.
So Alexander, you also have 15 minutes, okay?
Yes, I understand.
Okay.
So I'm sharing the.
Je vais aller en bas parce que ma connexion n'est pas très bonne.
Okay, so my name is Alexander Smivinsky.
Pierre, you are with your microphone is still open. Okay.
Okay.
Let us move.
I can continue. Yes.
Yeah, please.
Okay. So my name is Alexander Smivinsky-Pol, and I work at the AGH University of Science and Technology in Poland, and I will give you the presentation about the Polish question answering dataset for the legal domain. So the agenda is pretty short. I will start with the introduction to question answering as seen by the NLP in the field of NLP. Then I will tell you something about the neural models which are used for solving this task. And then I will tell about the dataset creation. And I will finish with some experiments, results of the experiments I have conducted for that dataset. So to give you some context, I specialize in applying the NLP tools in various domains and recently in the legal domain, which is not the primary topic of this workshop, but I think that the creation of a data set with question answer pairs is pretty relevant, especially for a justification of decisions. So if we want to create an AI agent which will play with the with law, which will be able to provide some answer for the questions in the legal domain, so such a data set is especially important. And I wanted to evaluate the available neural models in this particular context. I mean, in Polish language and in the law domain. So this is the motivation for my work. The most popular question answering data set for sure in the NLP field is SQUAD, which is a Stanford question answering data set. This dataset was created by taking some excerpts from Wikipedia and providing for these excerpts questions and answers. But the restriction was that the answers have to be always some spans of consecutive tokens from the excerpt. So since this is the most popular data set, it contains 100,000 questions and is all the benchmarks or all the new systems in NLP field use SQUAD as a benchmark. I decided to create this legal domain data set in similar fashion. So the primary restriction is that the answer for a question is a part of a legal provision. So my research question was, are domain independent English only data sets good enough to create a QA model for the legal domain that would work for Polish? This question might seem strange or irrational, because why should we trust that the English only data set can be enough to answer questions in Polish? But in fact, many of the neural network models can work cross domain. So This is not an irrational question. Moreover, as the data set is really large, it contains 100,000 questions, so it contains some questions regarding law. So I wanted to see if we can only stick to squat, or we have to create such a data set. So let's move to the neural models. There are two models which has to be mentioned if we want to tell us anything about modern NLP. First one is GPT-1 from OpenAI. This model is particularly important because it introduced the idea to split the training of the neural network into two phases. The first phase, namely the so-called pre-training, is used to create a language model that is universal. This task is time-consuming, but since the model is universal, you can then use that model for some other so-called downstream tasks, like question answering. So the idea is that first you train the universal language model, and it's very time consuming. It might take several days or even weeks. And then if you want to solve a particular task, you just fine tune the language model for this task. What was so important about BERT, which used the same architecture, which is called transformer, and this architecture is depicted on the picture, is the fact that it included the so-called bidirectional language model, which means that it used the whole to resolve a specific task in the language modeling. It used both context of the word. So BERT became de facto standard at present, and is definitely is the most popular neural network model for NLP tasks. So I will refer to BERT in the following slides. But what is so also very important, when BERT was published, when the paper about BERT was published, it's one of the benchmark used for BERT was Squad. So and it improved the state-of-the-art results greatly in that benchmark. So this is why BERT is also very important for question answering. Okay, how the task is modeled in BERT. So the question and the reference text are fed into the neural network. And there are some special tokens. The most important is separation token, which separates the question from the answer. And the neural network is supposed to identify the first and the last tokens of the answer. So that's how it's constructed. It could be constructed in a different way, like token classification. So we could have answers which are not consecutive tokens, but originally it was not devised in that way. So this is why I decided to follow the same principle. Okay, so let's now move to the dataset creation. Okay. So we have an example of a question and answer, which the questions and the answer were taken from the official exam for the legal trainees in Poland. Each year, the question and the answers are published. So they are publicly available, but obviously they are not provided in a structured way. They are provided as PDF files. So there was substantial engineering work to convert this data set into something which could be used for machine learning. So here we have the question and the answer. The question always includes 3 possible answers, and the answer indicates which answer is the the option, which is correct, and also it includes the legal base for that answer. This is the very important thing for the task, since if you want to create a data set, we need the text, we need the context for the answer. So the idea was to first convert these PDFs of questions and answers into structured format. I used JSON for that. Then structure the references and then retrieve, based on the reference, retrieve the regulation contents, the provision contents, and then match the answer with the regulation, with the provision. So this is the that was the schema of the process. Regarding the reference structuring, actually I have presented this this problem at ICAL, so I won't get too much into that. We use a machine learning approach for that, so we can identify the tokens which form particular types of references, both for the individual provisions as well as the titles of the provisions. So at this stage, the reference to the legal base is structured and converted into a format which is which unambiguously identifies the particular provision. At the next stage, the metadata of the bills were loaded to Elasticsearch to allow searching for the titles and searching for the most recent version of the bill. This is very important, since there are many amendments to even to the most important, like civil code or penal code. There are many amendments, so we have to have the most recent version of the bill. And by identifying the metadata, it was possible to identify the particle contents, but still Polish law is usually distributed as PDF files, which are very hard to process, but some of them, nobody knows which, are distributed as HTML files, which are not, which is not XML, but they are pretty well structured. So basing on the structure reference, it's possible to identify the particular content of the provision. So, and the last stage of the dataset creation was the matching between the answers and the text of the legal provision. It was there were several restrictions related to that, but the most important one was related to the fact that I wanted to follow the squad structure, so only the consecutive tokens were identified. So starting with 6,000 of question answer pairs, I was able to extract 3,000 question answer pairs, which followed this particular restriction. So it's pretty large data set. I mean, obviously not as large as Squad, but regarding the legal domain, I think it's pretty huge. Regarding the experiments, I wanted to test several models which are available for either for Polish or for their multilingual. So as a baseline, I used multilingual BERT. Then I used the so-called Polish Squad, which is a multilingual BERT trained on the automatically translated Squad. And then I compared Polish BERT, which is a model trained from scratch on Polish text. And as the last one, I used MLR. It's a very large model provided by Facebook, which was trained on, I think, 100 languages and maybe, I think, terabytes of, as far as I remember, terabytes of text. So the results are pretty interesting. The most important thing is that the XLMR model from Facebook is the best. what was interesting for me was the fact that the Pol squad, so the model trained on the Polish version of Squad, I mean, automatic translated is much worse than the version trained on these multilingual resources. So the answer to the research question is that it is necessary to create such a domain specific and language specific data set which justifies this research. But also the interesting fact is that the Polish bird, Polbird, when we compare, that was the second best performing model. When we compare the exact match and F1 score on the validation data set, we see that the differences are not as large between Polbird and XMLR because it's only 2 percentage points. But when we look at the test part of the data set, we see that the drops in performance are pretty huge for the Polbird, where it is 10 percentage points for the exact match, and for XLMR it's only 5 percentage points, which means that this very general language model trained on a large number of textual resources, it works much better in that context than this smaller Polish Polish model. So to finish, I encourage you to download the data set. Today you can, it's publicly available. Thank you for listening to my presentation. Okay.
Thank you very much, Alexander. Very, very interesting. And I believe now Pierre has fixed his problem. So I would immediately give the word to Pierre. So you have 15 minutes.
I stopped sharing the presentation.
Okay. Pierre, if you have any problem to share your screen or use the video, then Roberto can share, and then you turn off your video, okay? Pierre? Is Pierre here? No, he's not anymore in the list.
Excuse me, Professor. Pierre is on the list, actually.
Yes.
He's mute, actually. Wait. Now he left.
Yeah, I don't see him in the list of participants. Let me interrupt the recording, then I can. Yes, yes, I will start recording again. So please, Pierre, you can you have the word now to start our presentation, which will be the next one of our workshop. You still have 15 minutes. It will be shorter for discussion, but I think 10 minutes it was really difficult to cover the presentation. So please, you have the word.
All right. Do you see my slides?
Yes.
All right, good. Well, again, sorry for that. Not sure what happened. But so I guess I'll start again from the beginning. I'm a PhD candidate at KU Leuven in Belgium under the supervision of Mark de Necker in the Knowledge Representation and Reasoning Group. And I'll start by explaining the concepts in the title. So Interactive Advisor, the department has been developing over the years Interactive Advisor under the following model. A user in facing a situation in the real world can enter observations and tentative decisions in the Interactive Advisor, who will help him reason correctly about the problem. And in return, the system will give him the consequences of his observations, the prerequisites of his decisions, and explanations. all that with a knowledge base expressed in first order logic. Someone says he doesn't see the slides. Okay.
Right, I actually see your notes instead of your slides.
Okay.
It's probably not
Maybe I need
intended
to
like
share
this.
the other screen.
You may just have to restart the presentation.
Let me go here. I may have to stop sharing and share the proper. This one, I think.
Yes, perfect.
All right.
Thank you.
So that was the knowledge base is expressed in first order logic, and which is quite flexible to describe any problem domain. And actually, the system is in use by an industrial partner for an engineering application. So our idea now is to try to apply it to legal applications, but of course that presents some challenges. So for lax legislation, the title says, basically we are using a model-based approach. So the knowledge base is a logic theory that describes a set of possible worlds. And so the knowledge base can be conflicting if there are no possible worlds, the statements in the theory are conflicting, or deterministic, there is only one possible world, or lax in the sense that there are several possible worlds. And that's what we are focusing for the moment. And the interactivity of the tool allows the user to explore the various options for the situation he has. And finally, the title says observable situations. We take the assumption that the situation is not fully known at the start of the search, but the user can obtain more information by observing his environment. And here, the environment would be, for example, a legal case. Traditionally, I mean, the system has been developed over the years. In this work here, I'd like to focus on our contribution, which is relevance. Which observations are useful to come to a recommendation? This is important to avoid the user having to do too many observations. That's extra work for him, and he can enter just what is needed. And secondly, the contribution is about correctness. When the user makes tentative decisions, that is valid only under some hypotheses in the environment, and those hypotheses must be verified. And again, we would like to limit how many things he has to check before he can accept the solution as correct. So far, our system was based on only one knowledge base containing a vocabulary and the laws of the problem domain. And the key idea here that we introduced is to split that into two parts. One vocabulary describing the legal situation, i.e. the case, and another vocabulary describing the course of action that can be contemplated and their consequences. Similarly, the knowledge base can be split in two, one with the laws of the possible situations, and another one with the laws of the valid legal advice, which are the constraints about the legal decisions that he can make. And so we formalized the approach using these two theory settings. And so the legal advice problem is then defined like this: given a total description of the situation, a logic theory of the possible situations that the user may face, and a logic theory of a valid advice, then the problem is to find a total advice, that is a full set of decisions that satisfies the theory of advice. And you have the formula at the bottom of the screen. And then once we have that, we can build an interactive process. And in that interactive process, the user makes observations, decisions, and he may also retract decisions. so that at any point in the state of the process, the state is described by a pair of partial descriptions containing the set of observations and the set of decisions that are active. The key assumption here is that the user makes perfect observations. That is, the observations are compatible with the situation that he faces. Then with that, in any state, the system can check the consistency and check that the user is in the right track to find a solution. Consistency is defined as being a state where there is a possible situation consistent with the observations and the theory of situations, and for which there is a refinement of the decisions that together satisfy the theory of advice. And again, you have the theory formalizing that below the screen. And so with that consistency check that this system performs, the interaction works like this. Initially, the state is empty. There is no observations and no decisions. And then the user can add observations. That's indicated with the plus before the observation. Adds decisions or retract decisions. And then there are two cases. Either the state is still consistent, is still on the right track, and it can continue. Or at some point, the system becomes inconsistent. And in that case, he has to retract some decision to go back on the right track. We formalize also what is a partial solution. And indeed, often it is not necessary to observe the situation fully to arrive at a practical advice or a correct advice. Also, some decisions may not be necessary. And so we define a definite solution as being a state such that for any expansion of that state that satisfies the theory of advice, then it is compatible with the situation. In other words, the partial solution contains enough decisions to ensure that whatever the situation the user faces, it is correct, it is valid. Then we define relevance, which, if you remember, is one of the key contributions we wanted to make. In a given state, a tentative solution is a minimal partial expansion of that state that entails the satisfaction of the theories. And we define then a symbol as being relevant in a state if it is uninterpreted in the state, but interpreted in at least one of the tentative solutions. So in other words, a symbol is relevant if it is an important symbol in a tentative solution that is accessible from the current state. Then the system, as it is often the case in advising system, can compute the consequences of a state. That is, facts that are true in every tentative solution for that state. And those consequences are useful for the user because then it doesn't have to make a decision about these. So if the consequences concerns a decision, it can be simply added to the state. But on the other hand, if the consequences is about the situation, then we cannot be sure that the consequence is true in the environment faced by the user. It must be verified by the user. And so it cannot be added directly into the state because the state must be consistent with the situation. That was an assumption that we made. So this helps the user in ensuring the correctness of the situation, of the solution that he finds. Finally, some consequences can be derived from the theory of situations based on the known observations. In that case, those consequences do not need to be verified because we assume that the theory of situations is valid, is true. The last slide contains links to a demo and access to the tutorial. This is a demo about a very simple registration legislation, and then a demo of the Belgian tax for real estate transfer, which is a bit more more sophisticated, and there's a link to the paper. I can try to link or share the demo screen so that you have an idea. Well, I don't seem to be able to do it for some reason. Let me see here. I'll stop. Unfortunately, I cannot switch to the other Chrome tab, so I'll have to stop my presentation here. Thank you for your attention.
Thank you very much, Pierre. I will then move for questions, both regarding Pierre's presentation and Alexander's presentation. And Pierre, we are going to create this file with all the presentations, and maybe you could also deliver the links for these tutorials. So
the link, yeah.
Yeah, we were asking to share the link for the demo. You could share it now in the.
Yes, I'll do that right away. Yeah.
Okay. Yes, great. Okay, so the first question is by Nico to Alexander.
So I think this is interesting work, but so I'm always a little bit skeptical about applying black box approaches to things like legal reasoning. So I think it's a good idea to use something like BERT for natural language processing because it just works best. But then if you really do reasoning, I think it's important that you actually apply something like a white box reasoner on top. Because if you apply BERT, there are so many examples where weird things happen. So there are at least two problems that are well known. So one problem is that these dialogue models usually do not know what they not know. So you can ask them questions like, for example, when or who was the first president of the USA and in which year? And then in the next question, you ask who was the president 100 years before that? And then, of course, the system should tell something like there was no president at this time. But because it does not know what it knows, it just gives some random answer instead. So this is one problem that could be problematic in legal reasoning, I think. And the other problem is that they cannot deal at all with simple logical reasoning that they have never seen in the training data. So this is in particular shown by examples that contain something like negation. There are these textual entailment engines, for example, that try to recognize if something follows from a premise or something like that. And if you take a formula like A implies B and replace it with a logically equivalent formula like not B implies not A, then the result will again be completely random. And it seems to me that problems like that could also appear in legal reasoning. So have you thought about something like safety mechanisms or perhaps applying something like a white box reasoner on top?
Okay, so there are many issues you have identified. Maybe the simplest one, or maybe not the simplest, but there is work regarding the lack of knowledge, for sure. For instance, Squad 2.0 has, the problem was identified in the Stanford dataset because it only contained the factual questions, so only the questions that there were answered in an excerpt. But in Stanford 2.0, Squad 2.0, there were also questions which didn't have answers for them. So they also were able, I mean, the models also can identify the questions that there are no answers for them. But obviously it's not like, it's not logical in a logical way. It's just, you know, end-to-end training. So I also wanted to say that maybe I haven't said that, but my background was in the past. I applied formal methods in NLP. I played a lot with Psych, and I also used, for instance, DBpedia and Sparkle and these tools. But nowadays, the field is dominated by the neural models. So yeah, so this is what obviously what I think is what could work well would be a combination of NLP techniques with formal methods. And I have some ideas how to do that. For instance, we can build a model to convert, for instance, the questions into formal queries, right? We have, for instance, a legal knowledge database, and we train a model, some kind of a neural models to convert the question into a query. So this is one of my ideas. And I agree with you that these models are really restricted in a way, yes, because they don't know what they do, that in some sense. But on the other hand, the progress in neural network is also fascinating in the sense, for instance, there is the GPT-3 model from OpenAI, which is able to, for instance, what is very interesting about the model, that you can provide a handful of examples, like you say 2 plus 3 is 5, and 10 plus 5 is 15, and it somehow magically learns how to do addition with a very small number of examples. This is also similar for...
I would be very surprised if you don't find counterexamples for that. I mean, maybe it does work, but for many things that they said it would work, it didn't work when people really...
Yes, I know. This is still like, there are also many, like, they are cherry picking some things, right? So the results are more fantastic if you read the paper, and then when you try to apply, so you find out that there are many problems. But on the other hand, when you look at the results regarding the question answering, unfortunately, I don't have the results of the people who participate in the exam. But that would be very interesting to compare, you know, the results obtained by people and the results obtained by the system, by the model, and compare them.
So I mean, don't get me wrong. I completely agree that the progress in natural language processing is very impressive, and that it wouldn't be possible without neural models. But I think if you move to something like legal reasoning or other safety critical areas, then
but
you need
as I
something.
said, I think the path is to combine and maybe to convert the sentences into formal rules. But I think I see my research as a step in that direction. In fact, I see that as a step in that direction. So I agree with you, in fact, but I wanted to see what is possible, you know, what is possible with the models. And
I was just wondering if you thought about putting something on top that is actually something like a white box.
I have an idea, for instance, to create a model that we learn from like a parallel, like we have a parallel corpora for English and French and so on. So building similar corpora for natural language and formal language, and creating a conversion from the natural language to the formal language, and then do the processing with formal methods would be, this is, I think, the way to go. But it's still not so easy to create such a corpus of such parallel sentences.
Yeah, of course. But there is actually some work on combining knowledge graphs with neural models, for example. So perhaps this is a direction that could be interesting.
Can you give some
yeah, I sent you some links later. It's probably not it's not perfect. So if you're familiar with this distinction between T boxes and A boxes, then it's actually more on the A box level, because that's what knowledge graphs basically are, and you want basically something like T boxes where you do where you have rules, and this is missing at the moment, I think. But perhaps you can add something there. This is probably the difficult thing. But there is some work. I will send you some links.
Okay, thank you.
Thank you. Any further question?
Maybe I have another question for Alexander. Have you considered whether you can also retrieve explanations for the answer given by the system? I'm saying that because I don't understand anything of neural networks, but I'm involved in a project where we tried to identify unlawful clauses and also to provide explanation through a neural method that tries to do that by using attention and this kind of methods. I wonder whether you are considering also this kind of, and we also have a Polish project, so it'd be interesting to start a link if you're interested to connect.
I'm very interested. I'm very interested. Yes, for sure. I think these methods may be applied for justification. That's also one of the directions I'm following. This research was particularly concentrated on the extractive question answering, but using the same data, I can also create a data set for the selective question answering, which means that you have a question and you have to identify the legal provisions that are relevant for the question. So these provisions may be used as a justification for the answer, right? So and there's also a lot of research but this research is more devoted to to search rather than simple question answering but there is also a lot of research recently which shows that also search may be improved by neural models. This is for the last, say, 3 years. They were applied. A lot of people try to apply the models, but only I think 1 year ago the neural models started to be better than this very famous BM25 method from I think 2004. So now the neural models are also able to better search for. The biggest problem here is that if you have very long text, then the neural models have really problems to analyze that long text. So that's one of the research areas that are really well developing right now. Okay. Giovanni?
Yes, thanks a lot. Yeah. Sorry.
So let's communicate and find if I can help you somehow with your research.
Thanks a lot. It will be great.
Okay, great. Any further questions? Christina has a question for Pierre.
Yeah, hi, Pierre. I was just wondering, would you be able to provide us a little bit more detail on how did you go from knowledge base to actual reasoning?
Yes, we use an SMT solver as a backend, so it's Z3. And this SMT solver is capable of doing model expansion. So if you give him a theory and a partial structure on the vocabulary, it will expand it into a full solution if it's possible. And from that basic inference, we can build the additional inferences that we need for our tool. Does that make sense?
Yes, thank you.
Yeah.
Okay, let me see if there is another question. Okay, actually, we are already close to the end. It's now maybe it's time for some words for closing the workshop. I would like to thank very much all the participants, all the authors who have submitted papers. I believe that we got a very successful workshop with very interesting presentations and very interesting discussions. I think that legal interpretation is really a big challenge for AI, for modeling, and for knowledge representation. I hope that this workshop will be just a trigger for starting a discussion and possible cooperations between the participants in further research. As I said, we will give you further details about the discussion of this Latin American journal on AI and law, and it will be, I would be really happy if the participants of this workshop could contribute to the first volume of this journal. But I cannot give details now because I'm still discussing with Thomson Reuters. But hopefully this new journal will come through, and then we will have a new forum for discussions on AI and law, which will be very important for developing the field in Latin America. I would like to remember you that the next ICAO will be in São Paulo in Latin America. So I think that's a nice perspective for development of this field in our continent. And again, I would like to thank you very much for the contributions and for the discussions. And this workshop was organized by myself together with Giovanni Sarto and Gabriella Pigozzi. So I would give the word for Gabriella and then later to Giovanni for them to say some closing words.
Hi, thank you, Giuliano. Thanks to all the participants. I'm sorry I couldn't participate as much as I wanted because I had also some teaching to do, so that's why sometimes I wasn't there. So for the talks, I had the chance to follow and to listen. It was very interesting. I also enjoyed the discussion. Of course, it's not as being there in the same room and having coffee and chatting together, but I think it was, we still had a chance to talk and to exchange ideas and to have ideas also for future work. So thank you very much. Well, Giuliano was very nice to say that we we organized it together, but I have to say that he did all the work. So thank you, Giuliano, and thank you to all the participants.
Okay. No. Okay, so I would also have nothing more to say. I would also like to thank Giuliano and also the assistants, that is Marco and Roberto, for being so efficient in putting everything together. And I would also like to thank the participants. The quality of the presentation was very good, and we had a great discussion. I think that new interaction and collaboration are likely to come out of this workshop. So even if it was only online, it was also an opportunity not just to present our work, but also to develop new links. So I think that in general, this workshop shows us how in the legal domain there are many challenging issues, and how it is possible to establish a great collaboration between lawyers and people having a more computational inclination. So great to be with you today. Best wishes to everybody for this evening and for the continuation of your work. Bye-bye from Giovanni.
Okay, thanks, Giovanni. Thanks, Gabriela. And so I'd like to thank you all again, and especially thank Marco Almada and Roberto Bonrause for the very helpful support on organizing and this meeting. So thank you very much, and hope that we all stay in touch for future collaboration and links and joint research. Thank you very much. Bye.
Bye-bye.